Lordship, praying to file my memorandum of appeal without certified copy, Lordship.
আচ্ছা বুঝি না ব্যাপার ওই ফোনটা বন্ধ কর ফ্যান চালিয়ে দিয়েছে কেন
বলা হয়ে গেছে হ্যাঁ আগে কিন্তু বলেছিল বলা হয়ে গেছে
yes
I was praying to file my memorandum without
when was the order passed
20th August 2025, Lordship. It's an order of an arbitrator in a Section 17 application, Lordship.
it's all very well but why already more than a month has gone by
I would not get a certified copy, Lordship, because it's an order
when did
from
you apply
Lordship, it's an order of an arbitrator. I cannot apply to him.
ছুটির আগে
Grateful.
My lord, item number 27, my lord.
yes
It may be fixed, my lord, after the vacation, my lord. I had a talk with the other side, my lord. I am for the respondent number 2, my lord.
commercial
Commercial, my lord. 27.
Dinesh Kumar Chaudhary
Yes, my lord.
who is your other side
Yes.
is it all right very well after vacation
Highly obliged, my lord.
May I have your lordship's leave to mention a matter? It's item number 29 of the non-commercial list of today, your lordship. Usha Pasari versus Satyanarayan Pasari.
yes
My lord, the interim order expires on the 30th of this month, your lordship.
to be mentioned tomorrow serve notice
Grateful.
serve notice
Lordships have kept not the Mohanlal Club Cricket Association of Bengal matter at 12:30,
yes
but we've received notice that a suit has been filed by the Goribari Lane unit
40 Goribari
40 Goribari Lane in the City Civil Court against the order of the Ombudsman, challenging the order of the Ombudsman, and they're trying to move an injunction application. We've been served with the plaint and the petition.
you are a party there
We've been made a party.
go and see what can we do
No, since your lordships have kept it at
yes,
12:30,
come and tell us at 12:30 what has happened what transpires there accordingly we'll deal with the matter
they realize the difficulty in not
Yes.
having challenged the order of the Ombudsman.
right let us see come back at 12:30 yeah
What can we tell you? We have simple item number 1 and 2.
Oh, one, my lord. Wait. My left hand was submitting, my lord.
he had just started he had not yet yes
Lord, I'm trying to protect an ad interim order of injunction.
yes
Lord, I'm trying to protect an ad interim order of injunction
yes
where Lord, directions have been given for filing of affidavits and the matter has been kept for filing hearing on 28th of October. So,
yes.
Lord, at the ad interim stage, Lord, in my respectful submission, the learned judge, Lord, has taken into account the prima facie the case made out by us, the balance of convenience, and whether the prejudice is such that we should be protected at least till the final hearing of the injunction application. Lord, directions have been given, affidavits are to be filed, and the matter has been specially fixed on 28th of October, immediately after the reopening. Now, this is so far as the hearing is concerned. Now, Lord, may I take your lordship a little into the facts of the case? Because it's not simpliciter a case of development agreement, breach by us, sale in favor of Hatishala. A little bit of a background may be necessary. As your lordships have heard, this concerns the Statesman House, which is about 6 bighas.
Is it still called the Statesman's House? No,
Yes, yes.
still
Yes, yes.
same name. Statesman limited company. Statesman is a limited company. Who is the
Yes,
proprietor?
yes,
Limited company. Oh, acha. Yes.
It's about 4 bighas, 6 chataks. 4 bighas means about 86 katas odd of property. Now, Lord, the Statesman ran into dues to the State Bank of India. The State Bank of India initiated proceedings under the Recovery of Debts due to Banks and Financial Institutions Act. the claim was about 47 crore. Now, my lord, there was a one-time settlement before the Debts Recovery Tribunal, and under an OTS, under the one-time settlement, the State Bank, my lord, agreed to accept a sum of 33.7 crore in full and final settlement. Lord, of the 33.7 crore, 1.68 crore and 3.30 crore was paid as upfront by Statesman itself. That left a balance about 28.7 crore. It is for this 28.7 crore that finance was required. Lord, a loan agreement was entered into between Statesman and Merlin, under which Merlin agreed to grant, and Merlin granted a loan of 29 crore. A mortgage deed was executed. The mortgage deed has a clause that the mortgagee would not enforce the mortgage or enforce the security without prior notice to Statesman. It's in accordance with Section 60 of the Transfer Property Act, the right of redemption of the mortgage. Now, Lord, so far as this mortgage deed is concerned, Lord, the right of redemption has not yet been exercised. There's been no attempt to enforce the security. There's been no notice issued to us that they want to enforce the security, no suit filed under Order 34, and Lord, no suit filed for foreclosure or sale. Lord, the mortgage deed is still valid, binding, and subsisting. Once a mortgage, always a mortgage. Lord, I continue to, Lord, the agreement of mortgage still binds the parties, and under the agreement of mortgage, I have a right to redeem the entirety of the property. Now, Lord, this 29 crore that was taken under the mortgage deed by way of loan, the parties arrived at an understanding as to how they would reconcile the accounts, and a development agreement was entered into between the parties, a joint development agreement on the same day. Now, Lord, your Lordship has heard on the previous occasion that the division between the developer and the owner was 52.5 and 47.5. That is so far as the arithmetic was concerned. But in fact, the understanding was that the owner and the developer would share the revenue, all the areas, if they were let out on rent or lease in the proportion of 52.5 and 47.5. And if indeed areas were let out, then the development agreement provided that there would be an apportionment and a division of the areas amongst the two parties. So, Lord, this is in fact, Lord, in part reply to one of the queries which fell from the bench on the previous occasion as to whether compensation in money could be an adequate relief. Now, Lord, the parties have not yet, under the joint development agreement, demarcated the areas, but portions have been let out, including a portion to Trent Limited. This portion to Trent Limited is a substantial portion, Lord, which relates to 3 floors, and under this agreement, about 36,000 square feet has been let out. It is not yet demarcated as to whether it's been let out from the owner's allocation or the developer's allocation. This lease is for 25 years without a right of renewal. On expiry of the lease, this property, this entire area, would revert to the owners. So, Lord, on expiry of the lease in favor of Trent, which is, Lord, the west side, the organization which runs west side, the property would revert to the owners, as would other portions of the property which would be let out, and another portion has been let out to different parties. So, Lord, I not only have a share in the revenue to the extent of 52.5, but also a right to immove property which would revert back to us. This is one aspect of the matter. Secondly, my lord, the development agreement provides that, if your lordship remembers how Statesman House is, Statesman's House has the heritage building in front. It's a class 2 heritage building. There's a prohibition on changing the nature and character of the frontage of the building. At the back, there is a space. There is a space for parking of parking of cars. This is the major portion of the the vacant area for parking of cars. And it's agreed in the joint development agreement that neither of the parties would have a right to sell. It would be developed as a parking space. The parking space would be managed by the developer, and the income from this would be shared between the parties as per the ratio agreed. Neither of the parties are entitled to sell out this portion. So, this is the second aspect in answer to the query which fell from the bench, that whether the entirety of the property could be sold. It could not have been sold. A substantial portion relates to the parking area. Thirdly, my lord,
Mr. Sen,
yes, my lord,
we are sure what you are saying will be borne out by the record.
100%.
The only question is whether that meeting dated whatever.
I'll come immediately to the
Yes.
meeting of 10th of May,
Yes.
and I'll show your lordship from the meeting without going into these aspects, which I'll come to later if your lordships require me, that under the minutes of the meeting, they were not entitled to sell. On a plain reading of the meeting, what the meeting essentially says is that Merlin wanted exit. In fact, this is the second attempt of Merlin wanting exit, and the agreement with Hatishal is the third attempt. The first attempt of Merlin wanting exit was when the financier called Shalini Gujral was brought in from Delhi. Shalini Gujral proposed that she would bring about 350 crore. An agreement was entered into, tripartite agreement. Later, this investor walked out on account of two reasons. That behind the back of all the parties, Merlin had created a mortgage in favor of Axis Bank by taking a loan of 50 crore without letting anybody know. And secondly, the principal director of Merlin, Sushil Mota, was under investigation by the Enforcement Directorate and the CBI.
The mortgage was for some other project.
The mortgage which was created was to get funds for another project they wanted to do elsewhere. So under these circumstances, the investor said, sorry, I can't have anything to do with this project anymore. They walked out. The second attempt was this minutes of meeting of 10th of May. Now, in terms of this meeting of 10th of May 2024, your lordship will find, I'll show your lordship the minutes. It is not a standalone document. It says it is in aid of the joint development agreement. What it says is that at that point of time, 2024, lordships remember that the building had not yet been completed. The completion certificate comes in May 2025. At that point of time, the parties could not have calculated as to what their revenue would be. But there was an anticipation of revenue, 52.5 and 47.5. Merlin wanted out. Merlin said that of my anticipated revenue, I'm putting a ballpark figure of 130 crore. You pay me 130 crore, which I value as my anticipated profit margin, anticipated revenue, and another 30 crore, which includes that 29 crore of loan, and another crore that they had put in as a security deposit. So total 160 crore you pay me, I'll walk out. If you don't pay me as per these installments that we provide in the minutes of the meeting, then permit me to assign my rights, my development rights, to a third party without reference to you. Nowhere in the agreement is there any whisper that they would be entitled to sell the said premises. What it says that we would acquire a right to deal with the project. The joint development agreement, I'll show your lordship, makes a absolute clear distinction between what is the premises, which is the 6 bighas of land, and the project, which is the developer's right of making the alterations and changes as per the sanction plan. So under the development agreement, they acquired, under the minutes of the meeting, they acquired a right, if at all, to assign their rights to another developer, the development rights to another developer without reference to us, not to sell the property. Because that would have been completely contrary to the development agreement, the terms agreed between the parties. But may I come to that and show your lordship and satisfy your lordship on that? Your lordship will find the minutes of the meeting are at page 394. Now, this is in volume 3. And Lord, I'll also show your Lordship the clauses from the joint development agreement, because that will, what I submit, Lord, will be borne out from there. Your Lordships kindly take volume 3, page 394. Now, Lord, only please keep in mind, Lord, that the completion certificate is of 14th May 2025. The minutes of the meeting is 10th May 2024, 1 year before that. At that point of time when development was still, Lord, in its nascent stage. Now, Lord, please see the minutes. The Statesman House, Kolkata is being redeveloped as a mall by the developer pursuant to a registered agreement dated 26 March 2019. This is a development agreement. Although it was initially planned by the developer that the redevelopment of the project will be completed within 42 months from the commencement of construction work, the structure of the old building was found in very poor condition. Then came COVID-19 pandemic. As a result of the aforesaid, it was not possible to complete the project within the initial estimation of time as aforesaid. The owner acknowledges the efforts put by the developer to rejuvenate the Statesman House building in spite of having many challenges to execute the work, etc. Then Lord, please see clause A. The owner, that Statesman, has agreed to purchase or acquire the right of the developer's share of revenue accrued under the agreement dated 26th May 2019 in the Statesman House project at or for a total lump sum consideration of rupees 130 crore and also refund rupees 30 crore paid by the developer to the owner against agreements dated 26 March 2019. That is the total of 162 crore. Then please see the schedule is there. The schedule of payments 15th August and thereafter on receipt of completion certificate. Then please, for the time being, ignore B. That is the method in which payment is to be made. Then please come to C. In the event the owner fails or is unable to fulfill commitment of payment of any of the aforesaid amount mentioned in clause A and or B above, and the loans or advances together with interest, the developer will automatically, it will be entitled to dispose the project, and I'll come to the definition of project, in its entirety for recovery of its all dues at its sole discretion and in any manner whatsoever without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard, and in turn the developer will act to the best of its ability. The developer at its sole discretion would be entitled to deal with in any manner the entire project to any one or more purchaser or lessee or the like of its choice at a consideration to be solely decided by the developer. And further, the developer shall, after retaining all the amounts payable by the owner to the developer to it as mentioned here and above, together with interest calculated till the date of receipt of the entire payment, thereafter make over the balance sums to the owner. If your Lordship please comes back to clause C once more, your Lordship will find that the expression used is the project. Now, my Lord, if your Lordship now, my Lord, please comes to the joint development agreement for once, my Lord. And Lord, if your Lordship, the joint development agreement, your Lordship will find is in the first volume. Lord, please, it starts, my Lord, at page 109. Lord, if your Lordship please comes to page 109 of volume 1.
Yes.
And Lord, please come to page 123, the definition of project. Right at the bottom of page 123. Project shall mean the upgradation as per the plan already submitted or to be submitted with KMC and other statutory authorities for their approval of the existing building on the said premises. Lordship finds the expression premises and project used in the same clause. By undertaking necessary addition, alteration, renovation, and conversion of the existing building and upgrading infrastructure and facilities thereof, including construction of new block thereon, and the common areas, amenities, and facilities therein, in terms of this agreement by the developer at its costs and expenses. Now, premises is also defined. If your lordships please see page 127. In the middle of the page, Lord, page 127. Said premises shall mean all that the piece and parcel of land containing an area of 4 bighas, 6 katas, 15 chataks, 7 square feet, be the same a little more or less, and the existing building thereon, namely Statesman House, situated at being premises 4 Chodringi Square. So, Lord, clear distinction is made. The minutes of the meeting only says you get the right to dispose of. It's a minutes of meeting which parties have signed without the presence of lawyers, by saying you're entitled to dispose of the project. I would understand if one gives it a businessman's reading or reads it in a way that makes good business sense, is that you have a right to assign your developmental rights. Now, not one or two clauses more, please come to page 131 of the joint development agreement. Because anything else would require a registered document. Because had it interfered with my rights, it could not have been done without a registered document. No, 131, Lord. Owner's representations. Subject to the said mortgage, owner is absolutely seized and possessed of all that the said premises. Page 131, Lord, 3.1a. Subject to the said mortgage, the owner is absolutely seized and possessed of all that the said premises. B. Owner has marketable title in respect of the said premises. Then, Lord, D. Owner has made all material disclosures in respect of the said premises. So, owner's representations are all in respect of the premises, not the project, which is the developer's obligation. Not one or two other pages. Not page 135 is very important, Lord. The Lordship will find in the developer's representations, project is mentioned. Whereas in owner's representations, only premises is mentioned. Number 4, developers' representations at page 135. Now, please come to 4.4. The developer has represented and warranted to the owner, and the owner has accepted in good faith the developer is not involved in any litigation that may jeopardize the timely completion of this project. 4.5. The developer has represented and warranted to the owner that it has complied with all statutory, legal, secretarial regulations and is not in breach of any law, etc. A timely completion of this project. Whereas in this very same clause 4, when it talks of mortgage, at 4.2, the parties use the said premises. The developer has represented and warranted to the owner that construction finance against mortgage of the said premises. So the parties were very conscious of the distinction between the two expressions. Lord, please come to Lord, page 135. The basic understanding, Lord, of the parties, 6.2 at page 137. Page 137, clause 6.2. By virtue of the rights hereby granted and in consideration of sharing the net sales revenue, the developer is irrevocably appointed and authorized by the owner to execute the said project and jointly with the owner deal with the unit spaces either on outright sale basis or on short-term leasing or rentals. Now, 6.4 is the parking space which I had mentioned in the first part of my submissions. The parking space of the new building, though to be owned by the owner and the developer in their respective proportion as aforesaid, shall be utilized by the parties on pay and park basis to be operated by the developer in consultation with the owner and share the net income after deducting operating expenses relating to parking as per agreed ratio. And not one last clause, not please permit me, page 139, the authority to enter, clause 7. Simultaneously with the execution of this agreement, the owner shall hand over khas, peaceful and vacant possession of the said premises, including the building, save and except the area.
Correct.
Not immediately after this, I shall not address your lordship on whether possession was handed over, because that is the argument of Mr. Chidambaram. Simultaneously with the execution of this agreement, the owner shall hand over khas, peaceful and vacant possession of the said premises, including the building, save and except the area occupied by HDFC Bank and owner's office, to the developer for execution and implementation of the project. The possession granted by the owner, the next portion is relevant for my argument with regard to possession, which I shall make. The possession granted by the owner to the developer shall not be deemed to be a transfer under Income Tax Act or under Section 53A of the Transfer Property Act. Page 139. So, not coming back to the minutes of the meeting, if your lordship please comes back to the minutes of the meeting, which was at volume 3, page and starts with page 394.
We were at 395. you were showing
395,
us,
Lord.
yes.
And I showed your lordship, Lord, that the developer automatically, 395C, the third line, the developer will automatically be entitled to dispose the project. That is, the owner's rights remain, the developer's obligation and rights as a developer could be assigned to a third party without reference to me. That's what it says. Not that my property can be sold off, as it happened. And what due diligence has Hatishala carried out, if I may not ask myself the question? Statesman House being sold off through a constituted attorney without any notice, letter, email, nothing, without any confirmation, without any information sought from statesman itself. And I'll show your lordship that on the day that the conveyance was presented before the collector, Hatishala did not even have the authorized share capital or the paid up capital to purchase this property. And it was acquired much later.
1 lakh.
2 months after that, when the deed was presented before the collector, they issued shares. It's an entire got up story which I've pleaded fraud in my plaint. Lord, we have enclosed all the details and that we have got from the Ministry of Corporate Affairs. The forms we have disclosed. Since I'm on the issue, your lordship will find that the indenture was received by the collector in March 2025. At that point of time, the authorized share capital was only rupees 50 lakhs for a transaction of 235 crore. The authorized share capital was 50 lakhs and the paid up share capital was 10,000. 235 crore is a transaction. And it is only in June that's monies came in for the purposes of creating this veil.
Conveyance was executed when?
In June
2025.
25. And monies came in June itself, 3rd of June. 29 June was the conveyance. 3rd of June, 4,90,000 shares were purchased at 49 lakhs to increase the paid up share capital and increase the authorized capital. So everything was done in undue haste, beyond my back. 29 June, conveyance executed. 2nd July, we receive an email saying that we have transferred. No details. 7th of July, the conveyance is made over to us. We file a suit. We terminate. We've terminated the joint venture, joint development agreement and the power of attorney. Now, Lord, if I succeed in my suit for declaration with regard to the notice,
Just show us that bit where you have interest in the property, not only in the sale proceeds, as you were
yes,
saying.
Lord. Lord, if your Lordship please comes to a joint development agreement, which is volume 1, and Lord, please come to Lord page 123 of volume 1. There's a definition of owner's allocation. Owner's allocation shall mean 52.5% of the net sales revenue generated from the sale proceeds and/or rental in case of lease or tenancy of units of the project comprising of various units. So either from the revenue or from the sale proceeds or the rental in case of leases or tenancies. And your Lordship will find there's a supplementary agreement. If your Lordship please comes to a supplementary agreement. And as I told your Lordship, there's a
Yes.
The right of demarcation of the property which has
Yes.
not yet arisen. That your Lordship will get at page 139. That if leases are given out, then it is required to demarcate. That your Lordships will get at page 139. Lord, 6.5. It is provided herein that if the situation arises anytime hereafter, the parties may decide to demarcate the units or areas in respect of their respective allocation on rateable basis. In such event, the party shall enter into a separate allocation agreement wherein the units or areas and proportionate common areas appurtenant thereto, together with undivided impartible proportionate share in the said premises, shall be mutually allocated by and between the owners and the developer, and each party shall then be entitled to sell or transfer its allocation separately. Now, there was a supplementary agreement after this, where not only I'll show your Lordship on the development agreement, everything with regard to the marketing of the project, acquiring purchasers or lessees was to be done jointly. But to re-emphasize the fact, a supplementary agreement was also entered into.
We are only concerned with the question if they could have sold the property.
Lord, with every amount of Lord persuasion I can muster, my respectful submission is they could not have sold. At best, they could have assigned their rights as a developer. Three reasons for that, Lord, I give your Lordship.
Yes.
Lord, three reasons very briefly, Lord, in one sentence I give why they could not. Firstly, because the minutes on which they rely do not give them that power. Secondly, my Lord, there are areas of this property which are to come back to us in the event lease is given out. And lease, in fact, has been given out in respect of two portions. Those are to come back to us.
West side.
Which is post-tense. Which is after the minutes of the meeting. So in fact, the minutes of the meeting, our averment is it was given a go-by, because the parties thereafter entered into a lease, which they would not have had the property been sold off at that point of time. So, my Lord, thirdly, my Lord, is that had my rights being affected, it could only have been done by a registered document and not otherwise. The development agreement being a registered document, it could not have been modified otherwise. And fourthly, my Lord, is that the property was mortgaged. And sale to a third party is a clog on my right of redemption. The equity of redemption that I have, that has been clogged by this sale. without any notice in terms of the mortgage deed, without any notice in terms of Section 69 of the Transfer Property Act, without any suit for foreclosure having been filed, it could not have been done under the Transfer Property Act. So, look, these in my respectful submission are substantive and substantial points to be argued, if not at the final hearing, at the suit itself. But even at the final hearing, because we are at the ad interim stage now. And not if the property is now sold, I get not, I'll be nowhere.
Did you refer to some supplemental
Yes, Lord.
agreement?
Supplementary agreement your lordship will find, which is in volume 1, page 25. Lord, please come to page 26, clause 4. In partial modification of the relevant clauses of the said agreement, the owner and the developer will jointly decide all aspects of planning, saleable super area calculation, size of saleable units, marketing strategy, type of mall, rates, marketing terms of payment in respect of the project. So, Lord, it was to be done by both of us together. And Lord, please have a look at page 26. One more, clause 1. Lord, page 26, first line of clause 1. It has been decided between the parties herein that they will share the net sales revenue and or areas of the existing statesman house and the new building, except for one portion, Lordship will find Bhattar has been disposed of, and fourth schedule, which has been referred here, is to be kept out of allocation, is to be kept out of the project and reserved for us. Now, Lordship remembers yesterday it was mentioned that we are taken only 1500 square feet. Your Lordship will find why we took that. Next page, clause 2. It was only on temporary basis to facilitate the developmental work that we agreed to bring ourselves down into this this shell, only to ensure that the work could do. But clause 2, first line, that the developer at the cost of the owner will provide a bare shell space measuring 1500 square feet more or less on the ground floor of the existing statesman house, with the provision of electricity and plumbing lines for its temporary office to facilitate the present redevelopment activity. This is why. Now, Lord, I need to address your Lordship on, Lord, the point raised by Mr. Chidambaram that we have given up possession, and if we have given up possession, we can't get injunction. Now, Lord, here, Lord, I may respectfully submit there's a distinction which the courts have drawn between giving up possession de facto and giving up possession de jure. Now, Lord, let me show your Lordship one or two clauses and then immediately come to the judgment on this division bench judgment. Lord, I've shown your Lordship page 139. If your Lordships once more come to that, of volume 1, page 139. And then I'll show your Lordship the possession letter, which they've relied on. Page 139, clause 7. Last 3 lines of clause 7. The possession granted by the owner to the developer shall not be deemed to be a transfer under Income Tax Act or under Section 53A of the Transfer Property Act 1882. So this transfer was not in part performance of my giving up possession. Now, secondly, Lord, please see the possession letter now, which it was shown to your Lordships on the previous day. This is volume 7, page 975. Volume 7 My lords, I've got the possession letter, page 975. By an agreement of date, we have appointed you as the developer to develop the subject property. In terms of the said agreement, we do hereby hand over to you the vacant and peaceful possession of the subject property, except the portions occupied by HDFC Bank Limited on the ground floor and our office on certain portions of the third floor, for the purpose of development of the same. This portion was perhaps not brought to your lordship's notice, this last portion, for the purpose of development. And Lord, please see my pleadings in my plaint. Lord, if your lordships are pleased to come to page 72 of volume 1. Because I think something was said that there is no averment with regard to this. Something might have been said. I may have been mistaken. Lord, please come to page 72, paragraph 19. The defendant number 1 got the sanction on 22nd November 2019. It was allowed to enter in the said property for the purpose of developing the same. Lord, kindly permit me to place the division bench judgment. I will
Yes.
No, this is 2018 SCC Online, Calcutta 16878. Lord, please come to paragraph 4. According to the revenue, since possession of the land owned by the SSC was made over to a developer, pursuant to an agreement of 7th February 2007 for construction being undertaken thereon, in view of amended section 247(5) of the Income Tax Act 1961, read with section 45 of the Act, capital gains ought to have been paid in the assessment year 2007-2008. Now, this was the issue on which the court went into this. Lord, please come to paragraph 5. The development agreement of 7 February 2007 envisaged that the developer would construct upon the land, and in lieu of such work undertaken by the developer would be entitled to retain 61% of the land and the proportional constructed area, while the balance 39% of the land, together with the construction thereon, would belong to the assessee. Now, Lord, please come to, Lord, paragraph, Lord, 13. The commissioner reasoned that since possession of the land was made over by the assessee to the developer, at or immediately upon the execution of the agreement of 7th February 2007, the transfer is deemed to have taken place at such point of time. Now, Lord, paragraph 15, Lord, if your lordship please sees. In particular, it is only the kind of possession that is protected under section 53A of the Act of 1882, which is to be regarded as transfer, and mere handing over of possession of an immovable property for any other purpose may not fall within the scope of the word transfer in section 247(5) of the Act. There could be myriad situations. There could be an agreement between a developer and a prospective purchaser of a flat, under which the purchaser would make some payment or even the full payment, and the developer would promise to construct and make over a flat at a future date. Merely because the consideration is paid and the agreement is executed, it would not imply that a transfer would take place. The transfer in such a situation would take place upon the possession of the relevant flat being made over to the purchaser, irrespective of whether the deed of conveyance is executed or not. In another situation, A may agree to sell an immovable property at an agreed consideration to B, subject to such consideration being paid. If B is then put in possession of the property and a part of the consideration is received, as long as B is willing to discharge B's obligation under the agreement, A cannot dispossess B from the relevant property, notwithstanding the conveyance in respect thereof not being executed. This is the essence of section 53 of the Act of 1882. The transfer in such a case would be at the time of the possession of the property being made over to the transferee. Then, Lord, paragraph 17, Lord, please take note. When the owner of a land enters into an agreement with the developer for the purpose of developing the land, the terms of the contract would indicate when the transfer would take place. There could be rare situations where the transfer may be simultaneous with the execution of the agreement, but where the owner retains any right in the constructed area that may come up in future, it would scarcely be a case of transfer taking place at the time of the execution of the agreement. The matter may be viewed from another perspective. Merely because de facto possession of the land is made over to a mason or a civil engineer for the purpose of making a construction thereon, it would not imply that possession is made over to the mason or the civil engineer for their enjoyment of the property. Such persons would be in de facto possession under the de jure possession of the owner and only for the purpose of undertaking the construction at the land in question. Now, Lord, insofar as we are concerned, in my respectful submission, this is what governs it. But if it's to be different, Lord, let the affidavits come and let us see what their stand is. Till date, there is no stand of theirs on affidavit. Now, Lord, as your lordships are aware, Lord, the judgments of the Calcutta High Court of Muktakeshi Da is very clear that merely because there is a concept of lease pendants, that is not a panacea. And your lordships court have held that when situations under Order 39, Rule 1 apply, that merely not parading 53A lease pendants, one should not deny injunction because that would lead to not only multiplicity but embarrassment. And Lord, in fact, Lord, Muktakeshi Da has not now been relied upon by the Supreme Court also in 2024. In 2024 judgment, the Supreme Court has not only gone into the question as to what are the situations in which injunction should be granted, but also to what extent your lordship's appellate court would interfere when there's exercise of discretion by the trial court, which does not appear to be perverse on the face of it. The lordships permit, Lord, may I show that judgment, Lord? 2024-11 SCC. Gopal Dakila. I think a copy we should run short of.
I know that.
Lord, if your lordships are pleased to see the facts from paragraph 3, the appellants herein, who are the original plaintiffs before the trial court, instituted special civil suit for declaration, cancellation of registered sale deed, and permanent injunction against the respondents herein, that is the original defendants. In the said suit, the plaintiffs file an application below, Exhibit 5, for grant of temporary injunction under Order 39, Rules 1 and 2, read with Section 151 of the Code. Then, Lord, if your lordships please come to paragraph 6, the last 2 lines. In the course of the facts which I'm not going into, the plaintiffs and the defend numbers 1 and 2 became joint owners of the suit property and their names were accordingly mutated in the city survey records. Then paragraph 8, plaintiff number 5 received a notice dated 2nd January 2019 issued by the city survey officer under Section 135D of the Bombay Land Revenue Code, inviting objections, if any, against the recording of change of ownership in respect of the suit property. It is the case of the plaintiffs that upon receiving the said notice, they inquired and found out that the defend number 1, on the strength of the aforesaid power of attorney, had executed a registered sale deed in favor of his son, defend number 3, in respect of the suit property. Being agreed by the aforesaid plaintiffs, instituted suit along with an injunction application below Exhibit 5, seeking the reliefs. Then Lord, 10.1. The power of attorney was executed in favor of the defend number 1 only, with a view to entrust the day-to-day conduct of administrative and procedural functions and not to enable defend number 1 to sell the suit property. Not pausing here for a moment, Lord, I missed out those, showing your lordships those clauses from the development agreement which give the powers. What are the powers that the power of attorney holder is to have? And they're all in relation to and in aid of the development work. They're not independent or dehorse the development work. So on that basis, they could not have been sold to a third party. I'll give you a lordship the clause note as soon as I finish this. It is on the basis of the said power of attorney that the necessary permission to put up construction on the suit property was obtained from Vadodara Municipal Corporation 1995. Upon completion of the construction of the showroom and start of the business operation in 1997, power of attorney became redundant but was kept preserved in the office. Then Lord, please come to 10.7. It was apprehended that defendants may execute third-party agreements in relation to the suit property, thereby defeating the rights of the plaintiff, leading to a situation wherein the plaintiffs would not be able to use and enjoy their property and may give rise to further litigation with respect to the suit property. Disposal of the suit may take some time, and thereafter, and therefore injunction was prayed for. Then, if your lordship please come to the stand of the defendants 11.6. The power of attorney is a registered document and was never cancelled by the plaintiffs, and the said power of attorney was used with the consent of all the signatories to it. Then trial court, your lordship will find, granted an injunction, and then the portion appeal before the High Court, which starts from paragraph 15. The stand taken before by the defendants before the appellate court. 15.1. The plaintiffs have failed to make out any prima facie case, as the power of attorney executed in favor of defendant number 1 is not under challenge, and thus no presumption can be drawn against it. The next relief sought in the interim injunction application is virtually the same as the relief sought in the suit. 3. No irreparable harm would be caused to the plaintiffs if injunction is declined, as the non-grant of relief can be compensated in terms of money. The plaintiffs have not been able to establish any of the necessary conditions required for injunction. And 4. Grant of injunction in favor of plaintiffs has caused irreparable harm to defendant number 1, as he is unable to utilize the property that he has purchased by way of a registered sale deed. That's Mr. Mukherjee's case. Then 6. Clause 5 of the power of attorney suggests that the power was given to undertake procedure for sale in reference to the income tax authority, and clause 6 suggests that defendant number 1 is empowered to fully utilize that power. That's Mr. Chidambaram's case. And 15.7. This is also Mr. Mukherjee's case. Defendant number 3 is a bona fide purchaser of the suit property for a sale consideration of such and such. Then, please come to the findings of the court. The High Court allowed the appeal. Lordships will find that at paragraph 17, first 3 lines. Then, please come to paragraph 19. Order 43 CPC specifies the orders against which an appeal lie. Sub-rule R of Rule 1 of the said order provides that an appeal would lie against an order made under Rules 1, 2, 2A, 4 and 10 of Order 39 CPC respectively. The law in relation to scope of an appeal against grant or non-grant of interim injunction was laid down by this court in Wonder versus Antox, India. Please come to the last 2 lines. The court, upon due consideration of the matter, took notice of 2 egregious errors said to have been committed by the High Court. First, the scope and nature of the appeals before it and the limitations of the powers of the appellate court to substitute its own discretion in an appeal preferred against a discretionary order. B is not required. Come to 21. Wonder is quoted. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of the first instance and substitute its own discretion except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court has ignored the settled principles of law regulating grant or refusal of interlocutory injunctions. The appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with the trial court's exercise of discretion. Then please come to 5. 25. What flows from a plain reading of the decisions in Evans and Charles Ostenton is that an appellate court, even while deciding an appeal against a discretionary order granting an interim injunction, has to A. examine whether discretion has been properly exercised, that is, examine whether discretion exercise is not arbitrary, capricious, or contrary to principles of law. B. In addition to the above, an appellate court may in a given case have to adjudicate on facts even in such discretionary orders. 26. The principles of law laid down by this court in Wonder have been reiterated in a number of subsequent decisions of this court. However, over a period of time, the test laid down by this court as regards scope of interference has been made more stringent. The emphasis is now more on perversity rather than a mere error of fact or law in the order of granting injunction pending the final adjudication of the suit. In Neon Laboratories, this court held that the appellate court should not flimsily, whimsically, or lightly interfere in the exercise of discretion by subordinate court unless such exercise is palpably perverse, perversity, etc. Paragraph 28 likewise reiterates Wonder that if equally possible view is there, the fact that there is a possible different view would not engage the attention of the appellate court to change the order. The basis for substituting review of the trial court should be malafide, capriciousness, arbitrariness, or perversity in the order of the trial court. Then, Lord, in 29, sham sale is quoted. Hierarchy of the trial court and the appellate court. Then, up here is Mr. Mukherjee says that, Lord, sham sale is a matter in which your
Lord,
lordship
learned
has-
single judge, my lord, the judgment was your lordship justice banished.
My judgment.
Yes, my lord, Mr. Kapoor was on the other side. I got accounts instead of injunction.
Oh, I see.
Lord, that went up
Division
to
bench?
division bench judgment. From there, my lord, the matter went up. What the division bench did was transferred the interim application to itself and passed, my lord, orders. So when it went up, this is the hierarchy of courts, my lord, which is and then it got settled. It matter came back before your lordship and it got settled.
This court in sham sale observed that the hierarchy of the trial court and the appellate court exists, so the trial court exercises its discretion upon the settled principles of law, and appellate court, after the findings of the trial court are recorded, has an advantage of appreciating the view taken by the trial court and examining the correctness or otherwise thereof within the limited area available. It further observed that if the appellate court itself decides the matter required to be decided by the trial court, there would be no necessity to have the hierarchy of courts. Then Montazo and 31 should not assume unlimited jurisdiction, etc. Not kindly see the principles governing grant of temporary injunction. Paragraph 32. In Anand Prasad Agarwal, it was held by this court that it would not be appropriate for any court to hold a mini trial at the stage of grant of temporary injunction. And we are at the ad interim stage here, not even at the final hearing stage of a temporary injunction application. The burden is on the plaintiff by evidence aliuende, by affidavit or otherwise, to prove that there is a prima facie case in his favor which needs adjudication at the trial. The existence of the prima facie right and infraction of the enjoyment of his property or the right is a condition precedent for the grant of temporary injunction. Prima facie case is not to be confused with prima facie title, which has to be established on evidence at the trial. Only prima facie case is a substantial question raised, bona fide which needs investigation and a decision on merits. Satisfaction that there is prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief, and that there is no other remedy available to the party except one to grant injunction, and he needs protection from the consequences of apprehended injury or dispossession. Irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be a material one, namely one that cannot be adequately compensated by way of damages. The third condition also is that the balance of convenience must be in favor of granting injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of mischief, substantial mischief or injury, which is likely to be caused if the injunction is refused, and compare it with that which is likely to be caused to the other side if the injunction is granted. If on weighing competing possibilities or probabilities of likelihood of injury, and if the court considers that pending the suit, the subject matter should be maintained in status quo, an injunction would be issued. Thus, the court in exercise sound discretion such and such. And what perverse is explained in paragraph 34. What is perversity? '58 Supreme Court. Muktageshi Tatade. Game budget. Better game budget. 87 SG. There. Lord, our traditional judgment of Mukta Keshi Dab, Lord, I'll be failing in my duty if I don't show it, Lord. Your Lordships are aware of this, Lord. I'll not take too much of your Lordship's time on this. The division bench judgment of our court, Lord, in injunctions, Lord, really decides 2 points. that doctrine of lis pendens does not apply as a panacea, and what relying on lis pendens as a reason not to grant injunction would lead to complexities, including embarrassment. And secondly, my lord, at the stage of court deciding an application for temporary injunction, at the ad interim stage, all statements made in the plaint and the injunction petition should be taken as accepted. And Lord, they use the word in true modo et forma, it has to be taken as correct. So there's no competing affidavit on record. Lord, these are the 2 points decided in the Mukta Geshida. Lord, very quickly, Lord, the judgment that not once a mortgage, always a mortgage, it cannot be, Lord, no contract can come in between, Lord, and modify that, Lord. That's not 58 Supreme Court, Lord, if your Lordship kindly sees. Detail of the country. In fact, Lord, the special bench judgment of which my Lord Justice Banerjee was a part, which had also gone into the issue of whether specific performance could be granted by a developer, I thought I would rely upon it, but that's a pre-amendment judgment. Lordship goes into the specific relief act before the amendment. Otherwise, not there also this issue is there that possession is not deemed to have been handed over, and it's a presumption that in case of immovable property, there is no compensation is not an adequate relief. But that's pre-amendment, Lord. Now, Lord, if your Lordship please sees, there's 2 portions I'll show your Lordship, Lord. Paragraph 4. It is an admitted case. It is admitted that the case is governed by Transfer of Property Act. Under section 60 of the Act, at any time after the principal money has become due, the mortgager has a right on payment or tender of the mortgage money to require the mortgagee to recover the recovery of the mortgage property to him. The right conferred by this section has been called the right to redeem, and the appellant sought to enforce this right by the suit under the mortgage. However, the right can be exercised only after the mortgage money has become due. And Lord, kindly come to paragraph 6. The rule against clogs on the equity of redemption is that a mortgage shall always be redeemable, and a mortgager's right to redeem shall neither be taken away nor be limited by any contract between the parties. So, Lord, this, as I said, Lord, is my third defense insofar as the minutes are concerned, that this interferes with my right of redemption. If it is to be construed in the way in which they are construing it, if it is to be construed as a right only to, Lord, assign their developmental right, then it does not. The principle behind the rule was expressed by Linley. Lordship, please see the last line. I'll not trouble you, Lordship, with the extract. The last line. It follows from this that once a mortgage, always be a mortgage. Once a mortgage, always a mortgage. The right of redemption, therefore, cannot be taken away. The courts will ignore any contract, the effect of which is to deprive the mortgager of his right to redeem the mortgage. One thing, therefore, is clear, namely that the term in the mortgage contract that on the failure of the mortgager to redeem the mortgage within the specified period of 6 months, the mortgager will have no claim over the mortgage property, and the mortgage deed will be deemed to be a deed of sale in favor of the mortgagee cannot be sustained. It plainly takes away altogether the mortgager's right to redeem the mortgage after the specified period. This is not permissible. For once a mortgage, always a mortgage, and therefore always redeemable. The same result also follows from section 60 of the Transfer of Property Act. So it was said in Muhammad Sher Khan. And Lord, paragraph 8, Lord, please have a look, Lord. After the 2008 6 No.
Yes.
Yes, no, the last point, but it remains with is the point that the mortgage, the development agreement being a registered document, and the mortgage deed also being a registered document, the rights thereunder cannot be abridged or taken away by a document which is not registered. But I have the citation, but unfortunately copies have not come. Lordship permits me to give a Lordship the citation and the paragraph number. I'm very sorry, Lord.
Accepted. I accept that is registered. Lord, I accept the proposal.
This is 2008, volume 6, SCC 745, 2008. Volume 6, Supreme Court Cases 745. 2008. What? 2008, Volume 6, SCC 745. 745. 745. Yes, sir. 745. Yes. So I was, so got it. My lords, I was relying on paragraphs 15 and 16 of this judgment, my lord.
That is all.
Lord, I had to.
We have to hear them also.
Lord, I'll just take 2 more minutes of your lordship's time. The powers which could have been exercised under the power of attorney. Lord, I told your lordship, but I forgot to give your lordship the clause, Lord. The powers which could have been exercised by a power of attorney holder under the power, the judgment, the development agreement. That your lordship will find at page 143 of volume 1. But if they have no right to sell, then this question would become academic, because if they could not sell, they could not have exercised the right under the power of attorney. 143, your lordships will find the powers are there at 8.5. 1, 2, 3, 4, 5. They're all in relation to development. Every one of them relates for the purposes of and in connection with development work. Now, Lord, please see 8.6. While exercising powers and authorities under the power or power of attorney to be granted by the owner in terms hereof, the developer shall not do any act, deed, matter, or thing which would in any way infringe or prejudicially affect the rights of the owner and or go against the spirit of this agreement. My rights include the right to have the property after the leases have expired, as well as the right to get revenue from the parking space. I am not right also to let out other portions of my 52.5% by way of rentals. So, power of attorney in which is deholds or contrary to this would be powers of attorney which are a nullity. And exercise of those power of attorney to execute documents which are not authorized either by the development agreement or by the minutes of the meeting or any other agreement between the parties would be a nullity. But in my respectful submission, protection is required, at least at the ad interim stage, till the matter can be heard out. Otherwise, I will be left without any remedy. Situation would be irreversible. But these are my respectful submissions.
May I just take, my lord, 2 minutes, my lord, one clause. My lord, as I understand it, my lord, my learned friend's submission is, my lord, the 10th May 2024 document, my lord, gives, my lord, no authority for sale, number 1. Number 2, my lord, the submission is, project is what could be disposed of. Project, my lord, is the right to develop and nothing more. Third, my lord, power of attorney, my lord, could only be in aid of the joint development agreement. If it causes the owner a problem, my lord, prejudices the owner, then, my lord, it could not have been exercised. These are the 3 broad points, my lord. Then, my lord, a registered document cannot be modified, my lord, by, my lord, a document which is not registered, etc. Now, my lord, I have, my lord, 2, my lord, short answers, my lord, to all this. My lord, kindly come to, my lord, clause 13. Because, my lord, I, my lord, wish to show your lordships, my lord, the joint development agreement, the power of attorney, and, my lord, the 10th May are all in consonance with each other and permit, my lord, this kind of sale. That's all that I want to show. And the second, my lord, if that is the case, my lord, they cannot, my lord, have, my lord, any right, my lord, to the property other than, my lord, money. So therefore, my lord, there will be, my lord, no injunction, because, my lord, there is, my lord, only, my lord, an owner's, my lord, share of the revenue. My lord, that's what I want to show. Now kindly come to, my lord, clause 13. My lord, first, my lord, I want to show that I had argued this point. My lord, that's very important because that's not dealt with at all, my lord, by the learned judge. My lord, why I say, my lord, it's perverse. Kindly come to, my lord, the impugned order, my lord, which is, my lord, it's, my lord, page 5 of the impugned order. My lord, in the memorandum of appeal, my lord, kindly just see it from there. Para 11, Mr. So-and-so, representing defendant number 2 submits that the conduct of the plaintiff is not good and no case is made out against the defendant number 2. He 1. Now, my lord, this conduct I'll show. My lord, while the matter was pending on a mentioning notice, my lord, without explaining, my lord, why it's getting mentioned, at 4:30 they went and submitted to the court that their possession of the entire property, my lord, was being transferred. My lord, the next day we came back, my lord, to say, my lord, that that was not the case, what the true facts were. Then the learned judge, my lord, preponed the hearing of the interrogatory application and, my lord, disposed it off. So, my lord, one of the main submissions we had, my lord, was that he has not come to court with clean hands and, my lord, in fact, has obtained orders, my lord, by misleading the court. That is number 1. This was argued and this is, my lord, recorded here, para 11. Then para 12. Mr. So-and-so submits that the plaintiff claims himself as owner of the suit property, but the plaintiff was not the owner of the suit property as on the date of filing of the case. He further submits that the plaintiff has admitted that on 2nd July 2025, the defendant number 1 has informed the plaintiff about transfer of property in the name of defendant number 2, and on 7th July 2025, the defendant number 1 has disclosed the conveyance. Even then, the plaintiff is claiming to be owner of the property. Then, my lord, para 13. So-and-so submits that the plaintiff has obtained interim order by making incorrect statement before this court. He submits that in the joint development agreement dated so-and-so, plaintiff agreed that plaintiff shall hand over cars, save and accept area occupied for so-and-so. He further submits that in terms had handed over vacant except the area occupied by so-and-so. Then, my lord, 14. So-and-so submits that in memorandum of understanding dated so-and-so, plaintiff admits that subsequent to execution and registration of development agreement and grant of power of attorney, plaintiff has handed over possession of property to defendant number 1. He further submits that in the memorandum of understanding, it was also stated that by virtue of a supplementary agreement dated 6 July, the plaintiff and defendant number 1 agreed that division of the constructed area would not include a so-and-so on the 3rd floor of the building. Now, I pause here. There was an agreement entered into with respect to the entirety of the property. I want to show that with another person. And my lord, my learned friend submission is all these were not authorized. Now, my lord, and my lord signed by statesman under the JDA. Now, my lord, kindly see, my lord, 15 submits that registration of deed of conveyance has handed over possession of property except so-and-so. Then, kindly see 16. So-and-so submits that if clause 13.1 of development agreement, clauses 23 and 24 of power of attorney and minutes of meeting dated so-and-so, it will be clear that defendant number 1 had the power to transfer the property by executing conveyance deed. He submits that plaintiff has not paid electric connection bills, due to which electric were also disconnected. He further submits that defendant number 2 has invested 235 crores in the property, and if any order of injunction is passed, defendant will suffer. Now, my lord, I pause here. None of these submissions, which spread over, my lord, 5 paragraphs recorded by the learned single judge, my lord, have been dealt with at all. That itself, my lord, amounts to, my lord, perversity, and I've taken perversity, my lord, as a ground of appeal. Specifically. Now, I want to show your lordships, my lord, the document, my lord, which has not been, my lord, the clause which has not been considered, my lord, is 13.1, my lord, of the development agreement. Kindly come to, my lord, the joint development agreement. My lord, it starts, my lord, at page, my lord, 1 minute. It starts at 109. 13.1, my lord, is at, my lord, 149. Sorry. My lord, I rely on this, my lord, to show that, my lord, project is not, my lord, the developer's, my lord, right to develop. That's number 1. Number two, my lord, it includes the entirety, my lord, of, my lord, the constructed area. Is covered, my lord, by this agreement. Kindly have a look, my lord. And my lord, the delay. Kindly see, my lord. 13.1. The principal policy decisions. Lordships have that, my lord. Regarding the marketing and transfer of the project. Kindly have a look. That is the total transferable constructed units in the project, including deciding the transfer price and revising the same from time to time, shall be, now kindly come to the next volume, Millard, taken by the developer. Kindly mark the words, volume 2, Millard, I think. Millard, kindly, Millard, shall be taken by the developer with the concurrence of the owner, which shall be decided by the owner and developer on a monthly or such other basis as may be deemed necessary by the parties. So, my lord, first, my lord, marketing and transfer of the project, that is, my lord, all or any of the constructed units shall be taken at least on a monthly basis, my lord, by the developer with the concurrence of the owner. My lord, 10th May 2024 is such a decision. There is no modification of the joint development agreement. It is, my lord, the method of working out as provided in clause 13.1. That's number one. Number two, my lord, now, my lord, kindly may I just read on. The sale considerations in respect of the sale of units of the project shall be collected by whom? By the developer and be deposited in a separate bank account. So, my lord, the units are part of the project. Then, my lord, in a separate bank account to be opened for such purpose, in short, called project marketing account. Then, my lord, no other bank account shall be used for deposit of the sale considerations from the project. Then, my lord, monthly statement, etc., etc. And your lordship seen, my lord, 13.2 now. Kindly come to 13.2. The developer is entitled to negotiate for sale, transfer in respect of the saleable spaces, units of the project, and to enter into agreement for sale, transfer, lease out, let out, conveyance, transfer, lease deed, or to grant any other right in respect of the various portions of saleable spaces, units of the project, receive earnest money, consideration, etc., etc. Then, my lord, 13.4. My lord, provides for deeds of conveyance, etc. And my lord, 13.5 is, my lord, in case of area allocation. The developer shall make over possession. There has to be, my lord, an area allocation. But it doesn't arise. Now kindly come to, my lord, the, my lord, owner's allocation. My lord, page 123. Owner's allocation shall mean 52.5% of net sales revenue generated from sale proceeds rental of units of the project comprising of various units and areas together with share in the same proportion in car parking spaces, together with an undivided proportionate impartable so-and-so in the land attributable thereto, and together with the share in the same proportion in all common areas. So this is the allocation. My lord, which is, my lord, of the net sales revenue. Only thing kept out, my lord, is, my lord, that's, my lord, 1,500. Now kindly have a look at the power of attorney. I want to show, my lord, some of the clauses there. My lord, page 135. What 135? Yeah. And that's
Shared in that.
correct. Correct. Now, my lord, kindly see, my lord, page 130.
Mr. Mukherjee, are you suggesting that they had no right at or interest in any portion of the property at all?
Except what they had retained, which has not been conveyed. I'll show, my lord, I'll show, my lord, their own document which they have signed.
What about the car parking space?
My lord, car parking, my lord, will not apply if the entire project is sold. I'll show, my lord, from their own document, my lord. Car parking, your lordship's right. If it was unit wise, then, my lord, the persons who get, my lord, the units would park their cars and, my lord, get a, my lord, had to pay parking fees.
In case of a lease, what would happen to the rental?
My lord, rental will come to me, the owner now. And that,
No.
no, that is under, my lord, 10th May. It provides for rentals also.
Under the joint
May.
venture agreement,
Correct.
what would happen to the rental?
Well, go to the owner and be divided.
No, before transfer to you.
No, and be divided, my lord, accordingly.
So before this transfer to you,
Yes.
they had no, Mr. Sen's client had no interest in the land.
None at all. My lord, there, whatever interest they had, my lord, that is 1,500. My lord, that is, my lord, has been, my lord, kept out, which is, my lord, retained by them. My lord, they are the owners. My lord, as on that date. There's no doubt, my lord, that they are the owners. Now, the power of attorney, my lord, authorizes, my lord.
That is a different thing.
Yeah.
Whether authority was there.
Correct.
But how can you say they had no interest in that?
No. They had the title. I'm putting them at the highest because I've got what they had. I'm not for, but what I'm saying is, my lord, out of sale, they were to get, my lord, only their share of sale proceeds. I am, my lord, this is, my lord, the understanding of the joint venture, my lord, the development, I'm sorry.
Transfer of Transfer of Property Act. What is this basically? Which means money becomes repaid. The moment the money, before the money falls due to the lender, money mortgages. Correct. So you are We'll come back just in 3 minutes.
But I want to make one thing clear. My lord, my case is not, my lord, that they never had a right, my lord, in, my lord, the property. The title is theirs. Development agreement, my lord, provides for, my lord, construction to be done at the expense, my lord, of the developer. My lord, developer, my lord, recovers, my lord, the dues, my lord, of 47.5% from that, and 52.5% is the revenue share. At the end of the day, my lord, once the project is completed, my lord, the sales, my lord, which happen, whether, my lord, before completion or, my lord, after completion, my lord, the sale proceeds, my lord, at the end of the day, because, my lord, is very simple. My lord, could, my lord, the owner, after a completion certificate, prevented sales, my lord, for the developer to recover, my lord, 47.5%. So power of attorney, my lord, on the face of it, my lord, I'm not holding a brief, my lord, for the developer, but that was our due diligence, the understanding that, my lord, this is, my lord, a power of attorney, my lord, coupled with an interest. Because what he spent, my lord, has to be, my lord, paid out. That's what I want to, my lord, show, my lord. But, my lord, the sale which has happened is by statesman to me, not, my lord, by the developer. I want to also show that. The power of attorney, my lord, has been, my lord, utilized. And I'll show, my lord, when the power of attorney, this is not, my lord, the only case where it has been utilized for sale. They're all on record. They have disclosed it. I'm now showing you, lordships, my lord, power of attorney, permitted sale. Now, first thing is, my lord, I've shown clause 13. It could, my lord, 13.1. It could relate to the entire project. And, my lord, the power was there, my lord, to sell. Now, my lord, not just that. Clause 8, my lord, kindly have a look at that in the development agreement. Clause 8, which was placed by my learned friends. And then I'll come to, my lord, the power of attorney. My lord, kindly take 8.5 at page 140. Is it 143 or 179? My lord, 143. 143. My lord, there are two sets of pagination. My lord, it's the, my lord, printed one. My lord, kindly see, my lord. The owner shall grant to the developer and or nominees a general power of attorney simultaneously with the execution of this agreement for the following purposes. My lord, first is plan sanction, then, my lord, necessary permission, and, my lord, construction completion of the project, my lord, connections, my lord, for create mortgage. Then, my lord, kindly have a look at 5. 8.5, clause 5. To negotiate for sale, transfer in respect of saleable spaces, units of the project, and to enter into agreement for sale, transfer, lease, out, let out, conveyance, transfer, lease deed, or to grant any other right in respect of various portions of so and so, and to receive earnest money or consideration, give valid, to sign and execute necessary documents for availing loan, so and so. And, my lord, apart from the aforesaid general power of attorney, the owner shall. Now, my lord, 8.6 was relied on. My lord, your lordships, my lord, 8.5, 1 to 4 was shown. I'm showing your lordships 5. And now, my lord, 8.5, kindly have a look. 8.6, while exercising powers and authorities under powers of attorney to be granted, shall not do any act, matter, or thing which would infringe or prejudice. Doesn't. It contemplates transfer. Now, my lord, have a look at the power of attorney. Kindly, my lord, have a, because I'm out of pocket by 235 crores. And I have a registered conveyance in my favor. Now, kindly, and I've got his right. I've not got anybody else's right. And, my lord, what he is to get, my lord, is his share out of these sale proceeds. Now, whether Merlin gives it or not, that's, my lord, a battle, my lord, between them. My lord, that sounds totally in money, my lord. Now, kindly have a look at the power of attorney. My lord, page, my lord, 201. And these were all, my lord, which were relied upon by me, my lord, in paragraphs 11 to 16. page my lord 201. This is on the same day, 26 March. Now, my lord, it refers to my lord. My lord, now, my lord, kindly come to my lord clause 21 onwards. My lord, page 209. My lord, 21, my lord, bottom. To negotiate for sale, I'm sorry, my lord. My lord, transfer in respect of saleable spaces of the project as defined in the agreement. Then, my lord, 22, to enter into agreement for sale, transfer, lease out, let out, or to grant any other right in respect of various portions of saleable spaces units of the project as mentioned in the agreement on agreed terms and conditions with the intending purchaser or transferee in respect thereof, and to receive earnest money or consideration from time to time, and to sign and give valid and effectual receipt or discharge, to sign and execute necessary for availing loan, etc. Then, to execute and register from time to time agreement for sale, lease, or any other document in connection with the transfer of undivided proportionate share in land comprised in so and so. Then 24, to execute conveyances in respect of saleable spaces of the project to either in favor of the purchaser or its nominees or so and so. And then 25, to present such conveyances. It's all there. Now, my lord, at the end of the day, my lord, I'm getting his right. And what's being kept out specifically, my lord, is, my lord, the, my lord, and kindly have a look, my lord, at, my lord, 27.
This
To
is
ask for,
the registered power of attorney.
yes, two documents executed on the same day, my lord, the joint development agreement and, my lord, the registered power of attorney. And 27 says to ask for, receive, recover from all transferees, purchasers, all consideration charges, etc., saleable spaces of the building and comprised in the said agreement, and to deposit the same in so and so sale account, etc. Then to hand over and deliver possession.
Saleable spaces of the project. Yes.
I'm sorry. Now, my lord, this is, my lord, the position. Now kindly come to the minutes, my lord, of 10th of May, my lord, 2024. My lord, that's at page 394, my lord. My lord, kindly take, my lord. My lord, it's also part of the conveyance. My lord, I just wanted to show one thing, my lord. Yes, my lord, but kindly take, my lord, page 326 or 394, my lord, whichever. Lordships are at 394. My lord, I'll read it from there. Oh, 394, yes. Now, my lord, kindly see, my lord, representatives, my lord, who are present. My lord, one person here, my lord, is important. My lord, representative present on behalf of Merlin Projects. My lord, other than my lord, the managing director of Statesman, my lord, Vishal Jain. Because after this, my lord, lease has been executed and my lord, this conveyance has been executed. Now kindly have a look, my lord. Now, my lord, the owner and the developer agree as follows. The owner has agreed to purchase, acquire the right of developer's share of revenue accrued under the agreement in the Statement House project at and for a total lump sum consideration of 130 crores and also refund so and so paid by the developer against the agreements both dated a total sum of 160 crores. Now, my lord, this is signed. It's a signed document. Now, my lord, by both. Then, my lord, apart from that, the owner has agreed that apart from the aforesaid amount of 160 crores, further liable to pay to the developer the following sums. Then, my lord, in the event the owner fails or is unable to fulfill commitment of payment of any of the aforesaid amounts mentioned in Clause A or Clause B above, and the loans advances together with interest, the developer will automatically entitled to dispose the project in its entirety for recovery of its all dues at its sole discretion and in any manner whatsoever, without any reference to the owner, and the owner consents not to raise any objection whatsoever with regard thereto, and also extend necessary cooperation to the developer in this regard. And in turn, the developer will act to the best of its ability. Then, the developer at its sole discretion would be entitled to deal with, in any manner, the entire project to any one or more purchaser, stroke, my lord, kindly note, lessee or the like of its choice, and at a consideration to be solely decided by the developer. And further, the developer shall, after retaining all amounts payable by the owner to the developer to it, as mentioned here and above, together with interest calculated till date of receipt of entire payment, thereafter make over balance sums to the owner. Now, my lord, if it is balance sums to the owner, it can't be, my lord, developer. It's only dealing with developer share. It's the entire project. Now, my lord, apart from the aforesaid agreement regarding transfers of developer share of revenue, paragraph A, and repayment of sum of so and so, there is a loan transaction, etc. And then, my lord, title deed, etc. Is, my lord, provided here. So,
Mr. Sen was making a distinction between project and premises.
None, my lord. My lord, my respectful submission is this is the understanding. In fact, this wasn't even argued before the learned trial judge. Subject to correction. At least when I was there, it wasn't. No. My lord. Yes, it wasn't. My lord, Mr. Dutt is on his, my lord. This was not, my lord, argued at all. Now I want to show your lordship, my lord, the lease and another agreement for sale for the entire property. Now, my lord, kindly take the lease deed. Give me page number. My lord, page 325, which is also done, my lord, under this. I'll do it.
Was there a mortgage in your favor? Of
Not
the
my favor, my lord. Merlin.
sorry. Merlin's
Yes,
favor.
Merlin had a mortgage. My lord, if Merlin had sold it off, my lord, without notice, my lord, it's not Merlin's sale, it's statesman's sale, my lord.
Correct.
Under power of attorney, it's statesman's sale, my lord. The section 60 point clause on equity of redemption, etc. don't apply here at all. My lord, it might suit them, my lord, to say, my lord, I will pay you for his share.
Yes.
Now, my lord, kindly have a look, my lord, at, my lord, 325, my lord, or of course. Yeah, I've got it. Now, I want to show something, my lord, very important. They have annexed these documents. Page, my lord, 257, lease deed. Sorry, 325, my lord, my fault. My lord, more common expression these days is my bad. My lord, kindly come to 325, annexure M. My lord. Yes. My lord, kindly see, this is a lease deed made 6th of March 2025. Now, between whom? My lord, kindly see, Statesman Limited, so and so, so and so, so and so, having its registered office at so and so. Now, kindly see, my lord, 5 lines from the bottom, through its authorized signatory. Now, who's the authorized signatory of Statesman? My lord, Vishal Jain. He is the person who has executed, my lord, this conveyance as well. He's, my lord, a senior executive of Merlin. I showed your lordships, my lord, the minutes of 10th May. My lord, he signs as authorized, my lord, representative of Statesman, son of so-and-so, marked as so-and-so, which expression of the first part. Now, my lord, kindly come to, my lord, yes, my lord, after that, son of Kamal Jain, authorized so-and-so, annexed with deed and marks, hereinafter referred to as, kindly note this. My lord, they're described as lessor number 1. Kindly see, my lord, lessor number 1 of the first part. Now, my lord, kindly come to 327. My lord, Merlin Projects, my lord, authorized representative, same person, Vishal Jain, and my lord, referred to as, my lord, lessee number 2, lessor number 2. Then, my lord, lessor numbers 1 and 2 are collectively referred to as lessors. Then, my lord, Trent. Now, my lord, they are, my lord, second part. Now, I want to show, my lord, even more interesting thing, my lord. It gets curiouser and curiouser, my lord, this particular, my lord. My lord, 3.1.1 at 329. My lord, Alice in Wonderland. My lord, kindly have a look, my lord, at 329. In consideration of the lease, in respect of the lease premises granted by the lessors unto the lessee under this deed and subject to the lessee having access to and the right to use and occupy the leased premises for the purposes of operating its business and subject to all other terms and conditions of the lease of this deed, the lessee hereby agrees to pay lease rent during lease term on and from so and so in the manner as stated in part 10 of annexure 10 to lessor number 2, to which the lessor number 1 has consented. So entire thing, my lord, is to go. Now, my lord, kindly see, the lessee shall pay to lessor number 2 revenue share stated in part 10A of the annexure 3 if the revenue share is higher than lease rent in the manner subject to other terms and conditions. The lessor number 1 hereby provides consent and authorizes the lessee to pay so and so, etc. Consequently, all invoices shall be raised by lessor number 2 alone for the entire lease rent and common area maintenance, and all payment shall be made. My lord, the paramount title, my lord, doesn't get transferred in a lease deed. My lord, the owner remains. But my lord, owner is now also, my lord, kindly note, as far as this document is concerned and the lessee is concerned, and the lessor number 1 for the purposes of lease is concerned, lessor number 2 as well. And the entire rental and common area maintenance charges go to them. It's not even as per, my lord, 52.5 and 47.5.
Mr. Mitro, we will take up your matter at 2 o'clock because we don't want to piecemeal this, then that, then again this. What happened in City Court? Your client has filed a suit, we were told.
Has the Ombudsman not ever take it?
Please come back with that instruction. Yes.
And 1-0.
Yes, Mr. Mukherjee.
Yes, now, my lord, kindly see, my lord, clause 5.10 as well. At page 335. Lessors have valid title, etc., etc.
Yes.
Everything, my lord. Now, my lord, what is important is, my lord, the memorandum of Malane judge has referred to it, my submission, to show this. Now, kindly have a look at that. Give that agreement. It's a Gujarat agreement. My lord, 688, my lord. This is, my lord, even before my lord, the 10th May. 668, my lord, kindly take volume 5, my lord.
688 or 6?
668, my lord, my. Yeah, I've got it. And this is before, my lord, 10th May 2024. This is of 21st of November 23. My lord, statesman, my lord, is my lord there. Shalini Gujral is there. Merlin Projects, my lord, is there. Now kindly see clause B, my lord. 669. Subsequent to execution and registration of development agreement and grant, the owner has also handed over possession for undertaking necessary steps for so-and-so. Developer and terms have started undertaking with further modifications, if any. Now kindly note, the owner and developer by virtue of the so-and-so of net sale proceeds respectively with an option of division of constructed area in the aforesaid ratio. Then by virtue, so-and-so, super built up area equivalent to 1500 square feet built up area on the 3rd floor of so-and-so. Then, my lord, total saleable areas, my lord, Power of attorney also talks about, my lord, saleable areas. Kindly see, my lord. Sharing ratio, total saleable areas, including car parking, will be shared between owner and developer as per demarcation on third floor of the building, etc. Car parking is also indicated here. And the owner and developer shall have right in common area for in the terraces 52.5 so and so.
So this agreement was memorandum was executed.
Yes. But then, my lord, Shalini Gujral backed out. Then 10th May, and my lord, we, my lord, on the basis of these 3 documents, my lord, execute. I don't know if there is a problem between Merlin or them. My lord, they knew about it. It's unbelievable they didn't know about the sale. Conveyance, communication, etc. Everything was given. They've annexed the conveyance as well. Now, my lord, mortgage, everything, my lord, is, my lord, here. And my lord, kindly see page 671. My lord, recital I and J, my lord, kindly see. The purchaser coming to know of such information and upon being satisfied, etc. and right title in respect, purchase party here to record there, so and so. And this was before completion. My lord, purchaser for purchase has agreed to a total after adjusting estimated value, out of which a sum of being equivalent to so and so for purchase of company and a sum of so and so 52.5. It's money, my lord, which is going. Then, my lord, how the payments are to be made, everything is there. Default remedies, other terms, conditions, etc. Now, kindly have a look, my lord, at my lord, the my lord conveyance deed, which was executed, my lord, in our favor, my lord. My lord, page 378. My lord, kindly see who has executed on behalf of statesman. My lord, they are described as the owner. And my lord, Vishal Jain, the same person, my lord, who's, my lord, executed the lease deed after 10th May. And my lord, it is subject to, my lord, 235 crores, page 316. And as per sale agreement executed, to agree total consideration inclusive of stamp, registration, etc. Sale deed is on as is where is, free from all mortgage, subject to so and so. I'm out of pocket by 235 crores. There's a registered conveyance, my lord, which has been operating, my lord, for 3 months. My lord, I've been paying, my lord, all my lord charges. In fact, today electricity has gone because statesman, my lord, has defaulted in another office. CAC has, my lord, stopped everything. This is, my lord, the position.
Anything more, Mr. Mukherjee?
No, my lord, my thing is, my lord, they had title, my lord, nobody is disputing that. But, my lord, it is a sale, my lord, done, my lord, pursuant to, my lord, the joint development agreement and the power of attorney. I have not, my lord, recovered it by a mortgage sale. My lord, it's a sale by statesman. Power of attorney, my lord, has been utilized. Power of attorney provides for this, and my lord, 13.1, my lord, provides, my lord, how the entire project can be dealt with. My lord, even, my lord, if it was parking space which they can retain, my lord, they have to give it out and recover, my lord, my lord, parking fees. They can't refuse to give it. My lord, parking space is defined under the JDA. My lord, that would be, my lord, instead of, my lord, sadly, my lord, instead of, my lord, newspaper, my lord, print media sales, my lord, parking fee will become revenue for, my lord, statesmen. That's what's happened. This is there.
Exam. People quality.
And my lord, just one that Supreme Court, my lord, on, my lord, which my learned friend cited, my lord, which I rely on actually. My lord, 2024-11, my lord, on discretion.
Yes.
Lord, I'm not troubling your lordship till para 31. My lord, Wander and Antox, then my lord, how it has, my lord, proceeded. Now, my lord, kindly come to, my lord, 33. At, my lord, this is, my lord, 2024-11 SCC 351. My lord, para 33. Now, my lord, kindly take, my lord, the impugned order, my lord, along with, my lord, what has been said here. My lord, the memorandum of appeal. My lord, the finding, my lord, starts from, my lord, 22 onwards. My lord, the cases are discussed, cases of the parties. Then, my lord, kindly come to, my lord, why I say, my lord, perversity. My lord, paragraph 31. Kindly have a look. Page 15, my lord, or in internal page 15 of the order. 15 to 17, my lord, are the reasoning. The power of attorney does not provide any power to defend number 1 to execute deed of conveyance for transfer of property to third party. The power of attorney only for purpose of implementation in the deed of conveyance, etc. Now, my lord, my lord, pause here for a moment. Power of attorney, even under the JDA, my lord, clauses, my lord, 8 and my lord, 13. Read with, my lord, power of attorney, clause 21 onwards, my lord, provides for, my lord, execution. It's completely contrary to a document put, my lord, by the plaintiff on record. It was their plaintiff petition. Now, my lord. Now, my lord, kindly see clause E. From the said paragraph, it reveals that defendant number 1 misinterpreted the power of attorney, though there is no power to assign to defendant number 1 to transfer the property. In the minutes of the meeting, it is recorded that if plaintiff fails to make payment so-and-so, defendant number 1 automatically entitled to in its entirety, but the same was neither incorporated in development or in power of attorney. Now, my lord, I pause here. Well, this is 13.1 working itself out. My lord, it's a commercial contract. My lord, what, my lord, the parties will do, how it is to be worked out is decided. It's no amendment, my lord, to the agreement. It's provided how they will proceed. So, my lord, when, my lord, the contract is implemented, at each stage when a decision is taken, power of attorney doesn't have to be amended. Agreement doesn't have to be amended. It's in terms. And to give effect to it, that is happening. Then, my lord, but plaintiff failed to pay the amount, then in the emails, there is no reference that defendant number 1 is going to register a deed of conveyance. Then, my lord, defendant number 1 has relied and requested for payment, etc., etc. Application, this is all against defendant number 1. To show, my lord, conveyance, my lord, had been suppressed. And then minutes of meeting do not typically provide legal standing to register a conveyance, as this requires valid agreement with proper legal title and potentially a power of attorney or prior agreement granting authority to sell. Minutes of meeting may record the agreement and breach, but that are not substitutes for a formal legal document and establishes defendant numbers why. Minutes may state that defendant number 1 right to sell due to plaintiff. This decision needs to be formally incorporated into the original development agreement. As per the case of has transferred entire property and defendant number 1 is prima facie, defendant number 1 cannot claim share over the property. The sale is by plaintiff, not defendant number 1. My lord, going under, my lord, the power of attorney. Considering the above facts, finds that plaintiff has made out prima facie case, balance or inconvenience that the plaintiff will suffer. Defendant so-and-so are restrained from changing nature, character, alienating, interfering with the possession of. Now, de facto possession admittedly is not there. Forget about de jure. My lord, the possession initially for development agreement. After that, my lord, when completion is done, my lord, they are talking about in the lease that, my lord, this is how, who is handing over. Similarly, my lord, the agreement before the minutes of 10th May, my lord, possession is of developer who is handing over. And that possession has been handed over to me. So, my lord, I am, my lord, today de jure and, my lord, de facto in, my lord, possession. Possession certificate was handed over, my lord, to and is recorded. And, my lord, most importantly, my lord, not, my lord, even, my lord, a reference to clause 13 on which I made my arguments. Even one sentence that referred to, no, we need not go into this at that stage. These are the facts, prima facie. I'm not saying, my lord, everything, my lord, has to be dealt with. Argument noted. But, my lord, if, my lord, I succeed in that, the reasoning given cannot stand at all. Now, kindly see, my lord, para 33 now. My lord, of, my lord, page 367 of the, my lord, Supreme Court judgment. Now, my lord, Placidum F. My lord, satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief, and there is no other remedy available to the party except one to grant injunction, and he needs protection from consequences of application. So, my lord, irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but only means that the injury must be a material one, namely one that cannot be adequately, kindly note this, compensated by way of damages. My lord, I've said, my lord, my first submission is, my lord, the learned judge, with the greatest of respect, my lord, has first ignored, my lord, the submissions made on behalf of the purchaser, and second, my lord, has, my lord, on the face of it, my lord, ignored the relevant clauses, my lord, of the power of attorney and, my lord, the joint development agreement. In coming to the conclusion that power of attorney gives no power of sale, and, my lord, the memorandum of understanding before it could be implemented had to be, my lord, put into, my lord, the, my lord, joint development agreement and the power of attorney. And now, my lord, injury, my lord, if it can be compensated by damages, my lord, at the end of the day, for any sale that happens, my lord, whether in accordance with JDA or not in accordance with JDA, my lord, they will, my lord, get, my lord, their share. So it can, my lord, be, my lord, compensated. The third condition also is that balance of convenience. The court, while granting or refusing, should exercise sound judicial discretion to find the amount of substantial mischief which is likely to be caused by the parties if injunction is refused, and compare it with what is likely to be caused to the other side if the injunction. The second aspect is missing completely as far as the purchaser is concerned. What will happen to me with my money stuck? It's not even in court. No consideration, my lord, for that. If on weighing competing possibilities or probabilities of likelihood, court, I'm sorry. And now, my lord, kindly have a look, my lord, at what is said here. My lord, page 368. My lord, after all this, my lord, 3 lines after Placida May. Thus, the court has to exercise its sound judicial discretion in granting or refusing relief of ad interim injunctions. And my lord, this case, your lordships would have noticed, my lord, on facts, my lord, the ad interim order, my lord, was, my lord, granted by the learned trial judge. High Court interfered with it. And my lord, kindly see the exercise of discretion by the learned trial judge. My lord, kindly come to clause 10 point, para 10.1 at page 358. My lord, para 10.1, 5 lines I'll read. The power of attorney, I'm sorry, my lord. The power of attorney was executed in favor of defendant number 1 to do what? Only with a view to entrust the day-to-day conduct of administration and procedural functions, and not to enable defendant number 1 to sell the property. Then, my lord, next, there was no intention to sell the property as it was purchased only for running a jewelry shop. Here, the substance, my lord, of the joint development agreement is construct and sell so that I monetize. And Merlin is told you construct at your cost. And the risk allocation is whatever the sale proceeds are. He could make a profit, he could make a loss. You'll only get 47.5. Then, my lord, kindly come to 10.3. Defendant number 1, in collusion with officials of the office, executed a sale deed of suit property without any sale consideration in favor of his son, that is defendant number 3, illegally relying on power of attorney. My lord, here we have 235 crores. There, my lord, there is nothing. Then other son of defendant number 1 and wife of defendant number 3 stood as attesting witnesses. So, my lord, now no actual consideration paid. But what does the sale deed? Kindly see what is happening here. Sale deed, my lord, 10.4. As per recital, 1.70 paid. And
anything on record to show that you have paid 235 crores?
yes. We have a memo. We have paid. There's no dispute, my lord, on that. Nobody has raised that issue. Conveyance is that. It's there. Huh? Where is it? My lord, kindly take the conveyance. I think it's there. Page, my lord.
325.
No, 393, my lord. Registered document. My lord, recording, my lord. Bank transfers, my lord, by check. How much through that and how much by check? My lord, everything, my lord, including TDS. My lord, it's all. And no such case that no, my lord, payment has been. I'm only showing your lordship.
Yes.
My lord, those are my submissions.
Would Mr. Chidambaram want to add anything? In reply?
Very briefly.
Yes.
Very briefly. Lord, I just want to make 5 minutes for this supplementing the facts of Mr. Mukherjee and 5 minutes on the law that has been cited by my learned friend. 5 minutes to the case law cited by my Lord, I'm handing up, I'm not reading it. Give the other side. A list of dates for your lordship's convenience. I just want to invite your lordship's attention. Well, Lord, I have put the pages of my appeal, but I have also put the pages of the Hatisala appeal on the right-hand side. H is a Hatisala, my lord. Now, what does it amount to? On facts, there is a serial number 4 is a joint development agreement. Serial number 5 is a general power of attorney. Serial number 8 is a supplementary agreement which they did not produce before the learned trial judge. We produced it. Serial number 10 is the memorandum of understanding executed between petitioner R1 and Mrs. Shalini Gujral for entire sale of the project. He brought Shalini Gujral, I've said so in the appeal, he brought Shalini Gujral, and all three, that is the owner, the developer, and Shalini Gujral, signed it for 290 crore. He has got his version of why Shalini Gujral backed out. I have got my own version, and I will say that in the affidavit. His version is also not on record.
On record.
All right. All right. I take back that statement. That's not, nothing turns on that. Serial number 11 is the minutes of the meeting. And then serial number 13 is a Kolkata Municipal Corporation completion certificate. Serial number 22 is the suit prayers. Serial number 24 is the learned single judge's order. Now kindly go back only for supplemental facts. After the completion certificate was issued at serial number 13, just allow me to show a few events. Kolkata Municipal Corporation issued the completion certificate. In the light of the foregoing, all these documents, petitioner exercised its right and conveyed the suit property to R2. This is on 27/6/25. Then 27(6), physical possession was delivered to R2, that is appellant 2. 2(7) is important, my lord. Petitioner appellant addressed an email to R1, the owner, intimating the sale of the property to R2 pursuant to exercise of its right under the MOM. Lord, this is Hatisala appeal will be volume 3, page 378. Lord, I missed it. Kindly note, my lord, it's Hatisala volume 378. I told him in exercise of his rights under the MOM, I have sold the property, and I told him as early as 2nd of July 25.
These documents were there before the learned single judge.
These were before the learned judge. Then 3(7), he addressed an email to me requesting a meeting for amicable discussion on the matter. On 2(7), I told him that I've exercised my right to sale. 3(7), he addressed an email. This is not before the learned judge. 4(7), I addressed an email to R1 stating that the sale of the property was as per the MOM. 4(7), R1 addressed an email to the petitioner alleging breaches of the development agreement and threatening legal action. These emails were not placed before by the plaintiff and not before the learned judge. Then, petitioner appellant addressed an email to R1, inter alia stating, sharing the deed of conveyance executed between the petitioner and an R2. Pertinently, petitioner called upon R1 to share its bank details for remittance of the balance proceeds. This is again as early as 7/7/25. R1 addresses an email to me on 14/7 alleging breach of the development agreement and consequently terminate. He completely ignores the minutes of the meeting. Then he files a suit 23/7. 1 month later, the learned single judge passes an order of status quo. And a further 15 days later, the learned single judge passes an order of injunction. Now, kindly see the order of injunction. The last paragraph, last but one paragraph. Paragraph 36. This is an Hatisala appeal, volume 7, 1016. Without conceding anything, I want to make a point on paragraph 36. My lords of Calcutta, considering the above facts and circumstances, this court finds that the plaintiff is made out a prima facie balance of convenience, and if at this stage an interim order is not granted, the plaintiff will suffer irreparable loss. I'm not conceding this, but be that as it may. Defendants, they are men, agents, and servants, and assignees are restrained, one, from changing the nature and character of the property, that is one, alienating the property, that is two, and the third one, which is completely without jurisdiction, according to the Supreme Court laid down law, interfering with the possession of the plaintiff. Where does the learned judge, I ask myself, come to the conclusion that he is in possession? He should have come to the conclusion he is in possession and then said, I have found that the plaintiff is in possession, and therefore I injunct you from interfering with the plaintiff's possession. There's no finding, because he does not even claim in his plaintiff, that he's in possession. And he does not ask for recovery of possession either. The law is, my lord, Timmaya, and followed by another judgment, which I'll refresh your lordship's mind about Timmaya. You must be in possession to sue for injunction against interference in possession. And if you are not in possession, you must ask for recovery of possession and then ask for injunction. Here, he does not, the prayers I showed your lordship on that day, there's no prayer for recovery of possession. There is no averment that I am in possession and I'm in possession against the whole world, or I'm in joint possession, or the new twist, I'm in de jure possession. There's no such statement. No such statement that I'm in possession, and the learned judge could not have given a order, injunction interfering with the possession of the plaintiff. That is my first legal submission on the facts of the case and the law. The second thing, my lord, my learned friend has already explained. Now, read the development agreement, the supplemental agreement, the power of attorney, and the minutes of the meeting together. All four documents are the same. Minutes of the meeting are later. All other three documents are the same. Development agreement, power of attorney are the same date, 26/3/2019. And according to me, the power of attorney gives me the right to sell the property. My learned friend has explained it, but if your lordships will allow me 1 minute, I just want to show the power of attorney. Kindly see the power of attorney. Hartisala, it is 201 in my volume 2. Just see the power of attorney. Yeah. 250. No, 250. It starts at 201, and kindly see clause 22 and 23. I've got it. I marked it. How many pages are there? Yes. What does some meaning has to be given to the English words, fellow? To enter into agreement for sale. The rest is not relevant. To enter into the agreement for sale, transfer, or to grant any other right in respect of various portions of saleable spaces, units of the project, as mentioned in the said agreement on agreed terms and conditions with the intending purchaser or transferee in respect thereof, and to receive earnest money or consideration from time to time, and to sign and give valid and effectual receipts or discharges thereof, to sign and execute necessary documents for availing loan, etc. Then 23. To execute and register from time to time agreement for sale, lease, or any other document in connection with the transfer of the undivided proportionate share in the land comprised in the said property in respect of the saleable spaces of the project, and to receive consideration therefore, and to present the above documents for registration and admit the execution of such documents. Together, my lord, if I can sell saleable spaces to 5 people, for sure I can sell all the 5 saleable spaces to 1 person. Which I mean, if I have the power to sell unit by unit to person 1, person 2, person 3, I can, if I get a good price, sell all the units to 1 person, which is what I've done. And he must succeed in the suit to say that this sale is illegal. At that stage has not been reached now. He is not in possession. I'm in possession. I sold. All right. Good luck to him in his suit. If he can set aside the sale, that That's a different matter. But at this stage, how can the learned judge come to the prima facie conclusion that I had no right to sell, without analyzing these clauses? The learned judge has not analyzed these clauses. My lord, that is the only thing I want to say on the facts. Now, on the law, my lord, I've made it. Lordships have already. Given your lordships already the judgment in Thimmaya. Let me. That is 2008, 4 SCC, page 182. I've given the judgment, my lord. You've got copies. Now, kindly let me read paragraph 10 again. They're rising at 115. 115. 115. I'll finish. Undisputedly, the suit was one for permanent injunction. And in such a suit, the plaintiff has to establish that he is in possession in order to be entitled to a decree for permanent injunction. The general proposition is well settled that a plaintiff not in possession is not entitled to the relief without claiming recovery of possession. Before an injunction can be granted, it has to be shown that the plaintiff was in possession. Here, there is no prayer for recovery of possession. There is a prayer for injunction in the application, and that injunction has been granted when, according to me, he could not have even granted a permanent injunction because there's no suit for recovery of possession. That is one. This judgment has been followed by the Supreme Court in actually, this follows a judgment. This is dated February 6, 2008. It follows a judgment of earlier judgment. This is Justice Pasayat and Justice Kapadia. Kindly see paragraph 8 of this judgment. Paragraph 8 alone. On the finding of facts, we do not wish to interfere. There is no reason to reverse the concurrent findings. However, suffice it to say that the lower appellate court should have dismissed the suit filed by the appellant only on the ground that the appellants have failed to prove that they were in possession of the disputed lands. Under Section 38 of the Specific Relief Act 1963, an injunction restraining disturbance of possession will not be granted in favor of the plaintiff who is not found to be in possession. This is followed by Thimmaya. Now, my lord, it remains 1 minute to distinguish the judgments that my learned friend has cited. Well, this has been followed in Delhi High Court. I'm not troubling your lordship. Now, my learned friend has cited 3 judgments. I'll only distinguish 2. One is 2018 SCC Online, page 16878, Division Bench of Justice Sanjeev Banerjee and Justice Gangopadhyaya. Now, kindly come to paragraph 17. This is the only paragraph. No, this is the judgment he cited. But he makes a distinction between, I compliment him, de jure and de facto. But look at the facts on which that statement is made. My lords have got paragraph 17. When the owner of a land enters into an agreement with a developer for the purpose of developing the land, the terms of the contract would indicate when the transfer would take place. There could be rare situations, etc. Skip that sentence, brother. The matter may be viewed from another perspective. Merely because de facto possession of the land is made over a mason or a civil engineer for the purpose of making a construction, it would not imply that possession is made over to the mason or the civil engineer. Such persons would be in de facto possession under the de jure possession. Here, I am not a mason or a civil engineer. I'm a developer.
I'm not a civil contractor.
I'm not a civil contractor. Under the Commercial Suits Act, your lordships have made a distinction between a development agreement and a pure commercial contract of engaging somebody. Your lordships have consistently made it. I've appeared before this court. One is a commercial suit, one is not a commercial suit. A development agreement is not a mason or a civil engineer. I have been given possession by a letter of possession on the same day that a power of attorney was given to me in a development. This distinction between de jure, so I ask myself, what is my learned friend asking? De jure possession. That is all he's entitled to get. He can't get de facto possession. But the learned judge, when granting an injunction, he interfered with the possession. If your lordship reads it as it's only de jure possession, let him enjoy that status, my lord. But physical possession is with me, and I've transferred it to D2. How can that physical possession be injuncted until affidavits are filed? And my lord, I can understand if after receiving affidavits, the learned judge has come to the conclusion that he is in physical possession and the whole world should be injuncted from interfering. But at this stage, when no affidavit is here, I've got the money, and I have also told him, send me your email at send me your
2nd July.
2nd July. No.
After this.
No, I'll check. Bank details. Serial number 20. On 7 July, I told him, please share your bank details for remittance of the balance proceeds. I've received the money. I've transferred it to him. Then the second judgment which I want to distinguish is 2024 11 SCC 351, where it follows Wander versus Antox, and Wander versus Antox is referred to in paragraph 51.
Footnote 7.
No, footnote 7. Footnote 7. Now, kindly see, Millet, paragraph 21. Paragraph 21. I'll just read and complete. In such appeals, Wander versus Antox is extracted. In such appeals, the appellate court will not interfere with exercise of discretion, except where the discretion has been shown to be an exercise arbitrarily or capriciously or perversely, and I emphasize this, or where the court has ignored the settled principles of law regulating grant or refusal of injunction. The settled principle of law is if the plaintiff is not in possession, he can't get an injunction. That is a settled principle of law. And Wander versus Antox affirmed that principle and said, if the judge ignores settled principles of law, your lordships can interfere.
Just the conclusions you highlighted that they completely wrong. 3 paragraphs.
Mr. Sen, we'll hear you. We'll hear you because in reply, but when is the question? We are 3.5 days away from the vacation. We can't hear one matter for the entire day. Come back tomorrow morning, we'll hear you.
Only 10 minutes, so maybe even less.
Milord, your lordships may hear him, but I thought he had replied and I was rejoining. If he wants to add anything.
No, it's because Mr. Chidambaram, certain arguments had been advanced by Mr. Mukherjee, particularly in reply, which were not argued in his.
I have no objection. I have no objection. I'm only pointing out that I have only dealt with his arguments. I have not made any new arguments. I've made.
Today, my lord, it won't be.
2 o'clock, 12:30 a matter was fixed, which we have rescheduled at 2 o'clock. That is also Mr. Sen's matter.
I was told that it won't go on.
It's not expected to go on for very long, I think.
It all depends on what the feedback is. I mean, a lot depends on that. What the feedback is from City Court. Mr. Sen, let's do this. Let's take up the CAB matter. If after that time is left. We'll take up this matter again. You finish off today then.
Well, look,
5-6 minutes.
the present injunction of the learned single judge is hurting us. It's creating utter confusion.
এগুলো নাও. We'll try today itself, Mr. Chidambaram.
Be deeply obliged.
Is there any other matter fixed after 2 o'clock?
3:30.
3:30, that's Ram's.
Mr. Banerjee's matter.
Manager to
What doing from morning? He is the one who's submitting, and then he puts the blame on me.
We'll be a little late in coming back because
Well, look, I have completed my arguments.
yes.
Can I?
You're free to leave.
That's good because we have a break-up lunch in the bar library.
Yes, we'll be a little late. It takes us 5 minutes to go and 5 minutes to come from our respective chambers.
Deeply obliged.
Non-commercial, for judgment, item number 1.
Appear for the appellant, my lord. Led by Mr. Mitra.
We have discussed various points. We have said that if citation is not actually issued when it's not necessary, we have quoted the rules of the original side rules, then no question of complying with 283(3). Therefore, we have set aside the judgment, sent it back to decide the probate application in the light of the observations made in this order. What we have written after this, it should be automatic. I keep moving it. We have basically, Mr. Mitra, we have said we completely agree with Justice Pine.
That is the foundation of my submission also. Yes. And then, my lord, interpretation of 283.
Okay.
But these, well, now tell your lordship, see here, the advocates, learned advocates, they are all manner beneficiary of your lordship judgment.
I see.
All victims. Victims.
You know, কি দিব আবার?
Non-commercial, item number 1.
But in the morning, your lordships wanted to know, my lord, whether any injunction.
Yes, because Mr. Sen told us that a suit has been filed by your clients challenging the order of the Ombudsman. And so we wanted to know the status of that.
Yes. Well, the suit has been filed, an application has been filed, which is due to be taken up tomorrow.
Now, let us tell you very frankly, Mr. Mitro.
Yes.
We can dictate an order, dispose of the appeal, it's going to be against you. That will have adverse effect on your city court suit with the observations that we are going to make and your trial court in this matter. The application pending before the trial court will, for all practical purposes, become infructuous. So we are not to suggest, but you can still take a call whether to withdraw this appeal. And because the trial court has not yet decided, it has held you have a prima facie case, but not passed the order, has put served directed notice. Now, take instruction. We are waiting.
Look, being inspired by lordship's observations, may I request your lordships to pronounce give a judgment?
Won't be fair.
We've argued whole hog.
Because this is bound to affect that proceeding also. Every proceeding it will affect.
Should not, because it's ad interim, but even then.
In that event, my lord,
We took a few withdrawals.
can it be sent back, my lord, with the observation that, my lord,
Yes,
the
because nothing has been decided, we are not going into
lordships have
anything.
not gone into the merits, my lord.
Very good.
And Lord, your lordships wanted us to put on record the order of the electoral officer.
Yes,
Lord,
yes.
put on record.
The same thing has to be.
We are not going into all this.
Yeah.
Now that এসো
এ দেখো
এই কিছু দাও কাগজপত্র কিছুই দিচ্ছ না
My lord, only thing is, my lord, your lordships have also taken note of the fact that, my lord, the person who has been, my lord, given the, or who has been given the chance to represent,
এসো লেখো this appeal is directed against an order dated August 26, 2025 passed by the learned judge, bench dash Roman 6, City Civil Court at Calcutta, entitled suit number 1851 of 2025, filed by the appellants herein. Stop. The paragraph. The appellant number 2 claims to be the honorary general secretary
yes,
of the first appellant club. Stop. The dispute in the present proceeding is between two groups of members of Mohanlal. Oh, sorry. No. The dispute which has led to the filing of the present proceedings is in fact between two groups of members of Mohanlal Club. Stop. In the present suit,
Lord, according to the CAV, there is only one club, which is at 57C Bagbara Street, not two groups of the same club. The Koriwari Lane is a different club which has been set up later on.
appears to be the dispute which has led to the filing of the present proceedings, appears to be amongst members of Mohanlal Club. Stop. Paragraph. The present suit has been filed. Where is the prayer? Prayer in the plaint.
well, the plaint starts at page 346. I'll give the
346.
my lord 367.
কি বললাম? Claiming the following reliefs. Page 367, 368 থেকে করে দাও. Paragraph. In the suit, the appellants herein filed an application. Where is that application, Mr.
75.
And the 400 is the.
And 400 is the prayer.
Filed an application praying for the following interlocutory orders. Page 400 or 401. Paragraph. By the impugned order, the learned judge directed notice to be served on the defendant in the suit, being the respondent herein. Stop. The matter has been made returnable. But order on October 28, 2025. Stop. Paragraph. Since the matter is pending before the learned trial judge and the learned judge has not yet decided the prayer of the plaintiffs for interlocutory orders, We are not inclined to go into the merits of the case. Stop. City Court has the same vacation as we do. Same. So it will reopen on the 24th. So there is no scope for preponing, no scope for preponing really. You will have inclined to go into the merits of the matter, merits of the case. Stop. We accordingly do not entertain this appeal. Stop. We request the learned trial judge to decide the injunction application filed by the plaintiffs expeditiously, without granting unnecessary adjournments to either of the parties. Paragraph appeal and application disposed of. Section 5 is there.
No.
Why 2 applications then?
So the intervention application.
Oh, disposed of. Disposed of. Disposed of.
Your Lordship, give us time to file our affidavit in opposition in the meantime.
They can do that, utilize this time, Mr. Mitro. Otherwise, they'll take time again there. Dispose of Korarage Lekho. The respondent herein would be at liberty to file its written objection to the injunction application by October 24.
On the reopening day.
Reopening day, file it. If they wish to file a rejoinder, they'll file.
Kindly give us till 28th. And
28th is fixed.
28th.
28th is fixed.
24th is a Friday, and I think 28th is Tuesday.
28th is then filed by 27th with copy to them by October 27, 2025. Stop. We have already noted that the learned judge has kept the matter on October 28.
Let them file, my lord. If they can file it by 27, they can file it by 24th also. At least we get the opportunity to file the reply.
That is
my lord,
Mr. Sen, try that. That's why I suggested 24th. So that
Is when we reopen.
yes, finish it off this side of the vacation. Do it.
Sir, my lord, I had
Our request. Do it. 24 karo. Reply there to comma if any.
Lord, the urgency was because of the AGM today. Once the AGM is over today, there's no further real urgency
It is
except for
a
the cricket
request
season.
by your senior friend. That is all. Which due deference to your senior friend's request. If you two settle the matter.
Please, 27.
As your lordship.
No. You please tell us.
As your lordship.
Do it on the 25th then, at least. 25. Reply there to any before the next date fixed, before the learned trial judge. Before the next.
Give it till 27.
Then 27th ही रखो.
No. I was only submitting in a lighter vein that the last line of your lordship's order in this matter can be the order in the other matter also.
Where's your other side? In this matter, then the next matter. এটা দেখো
Oh, Mr. Banerjee is here. Luckily, I said it before he came.
He wanted us to cut the matter short by saying that what order we recorded in the 2 p.m. matter that we took up can also be recorded in your appeals. The order was, since the learned trial court has not decided the matter, we are not inclined to it.
But since the learned judge has decided the matter, kindly suffered an order of injunction.
You please finish so that we get.
No, I won't take more than 5-6 minutes.
We get a couple of days to write the order. A lot of arguments have been made.
Lord, I just go to the root of Lord, what I feel may require some assistance by me, and not go back into whatever I've argued. What I could understand, two main pillars of Mr. Mukherjee's arguments. The first pillar is that the project and the premises have been, these expressions have been used interchangeably. Or in some places, particularly in the clause 13, which Mr. Mukherjee showed your lordship, clause 13.1, the expression project has been used so as to mean the immovable property itself in its entirety, so as to clothe Merlin with the power to sell the property apart from whatever it develops.
On your behalf.
On my behalf. The second and most second important plank is our arguments with regard to mortgage, the restrictive nature of the rights conferred under the Transfer Property Act Section 60 onwards are really meaningless in view of the fact that the conveyance has been executed by us, though not directly by us, through my constituted attorney, and therefore by us. Therefore, those arguments really have nothing really to stand, no legs to stand on. But if your lordship has any, if your lordship goes to the joint development agreement, I'm on the first point, the joint development agreement. I've shown your lordship the clauses where premises and project have been defined differently. I have shown your lordship the clauses where the expressions premises and project have been used in the same clause differently. Those are the clauses right from page 123 right to page 139 onwards. I've given your lordship the page numbers. Mr. Mukherjee has shown your lordship one clause from page 149. That is clause 13.1. If your lordships may come to that clause at page 149 of volume 1. And if I may trouble your lordships to take the first few lines only. It is dealing with spaces in the project. So it is dealing with spaces in the project as defined in page 123. And Lord, if your lordship takes that keeps that in mind, and the fact that the expression project draws its color from the definition clause at page 123, then the rest of this makes sense. At page 123, if your lordship sees the definition of project once more, it essentially means whatever is the activity that the developer will carry out. Additions, alterations, renovations, conversions, constructions, etc. So this is dealing with the spaces in the project. That means the constructions that have been carried out by the developer. It does not, again, it does not mean the immovable property. And while explaining, and this clause essentially, if your lordship now sees, the principal policy decisions regarding the marketing and transfer of the project. In other words, the policy decisions regarding the marketing and transfer of the total transferable constructed units constructed by the developer. Whatever has been constructed and added, renovated, converted by the developer. Who will take those marketing decisions? Who will take those policy decisions? That is what the clause deals with. It does not equate premises with project. It says in the premises where the construction is to be carried out, in other words, the project is to be carried out, whenever there are transferable constructed units in that project, who will take the principal policy decisions? And that, if your lordship please sees, at page 150, at page 151, that's the next volume, including transfer price, revising the same, etc., shall be, if your lordship comes to page 151, which is the next volume, perhaps not, shall be taken by the developer with the concurrence of the owner, which shall be decided by the owner and developer on a monthly or such other basis as may be deemed necessary. So every decision with regard to whatever has been carried out by the developer in the project, which has resulted in transferable constructed units, those have to be either let out or sold. Who will take those decisions? The two will take those decisions together. That's all this clause says. This clause does not say that the project and the premises are to be equated or to be used interchangeably, or that the project is equal to the premises, and when power is given to sell the project, it means power to sell the premises.
Yes.
So, my lord, I make this distinction that even in clause 13, there is no power to unilaterally sell the property. And but if your lordships feel that there is any dichotomy, or there's any confusion, or there is any ambiguity in reading the expressions in the different clauses, the usual way of interpretation is that, unlike in a will, here the former clauses will prevail. And the former clauses
Yes.
So, my respectful
Construction is complete.
Construction now is complete.
Now is complete.
Construction now is complete. May 2025 is the completion
Certificate. CC
May
the
2025. That's the date of the completion certificate, May 2025. Bosh now. Now,
Yes.
so, Lord, when the minutes of the meeting gave the developer the right to dispose of the project, Lord, when the minutes of the meeting gave the developer the right to dispose of the project, it gave the developer to dispose of the rights which were conferred upon it under the development agreement, not my rights. This leads me, Lord, to the second argument, that in fact you have conveyed your rights by exercise of the power of attorney, by the sale transaction having been undertaken by between Hatishala and statesman acting through its power of attorney. It is statesman that has sold. Therefore, where is the question of this issue coming into it at all? Now, then I go back to my original argument. This is a mortgage property. I am the mortgager. Under law, I can create a lease with consent of the mortgagee, or I can request the mortgagee to transfer its mortgage, the value of its mortgage. As mortgager, I cannot sell a mortgage property because once a mortgager, always is a mortgager.
If the mortgager and the mortgagee agree,
No, that would then that would require me to first redeem the mortgage. Either I redeem the mortgage, either I redeem the mortgage, or in a suit filed by the mortgagee, there's a decree for foreclosure or sale obtained. But otherwise, Lord, by a document by a power of attorney holder, I'm not on the challenge to the power of attorney because that is to be decided at the trial. Because I've said that's vitiated by fraud, etc. and all that. By the document by which statesman enters into an absolute sale of a mortgage property without statesman itself having redeemed the mortgage, redeemed prior in point of time, or there being a decree in favor of the mortgagee in a suit for sale and foreclosure, the sale cannot take place. Now, Lord, insofar as the Transfer Property Act is concerned, Lord, in my respectful submission, there can only be a lease, or Lord, perhaps there could be only a assignment of the mortgage debt, again with the consent of the mortgagee, but no sale. Now, Lord, it is an admitted position, and both parties, both Hatishala and Merlin, go on the basis that merely the development agreement is insufficient for the sale to have taken place. The development agreement with the power of attorney is insufficient. What makes it sufficient is the development agreement, the power of attorney with the minutes of the meeting. The three combined together conjointly, and that is the recital in the sale agreement also. The three together conjointly make it possible for the sale to take place. If the sale is to take place by virtue of the powers conferred by the minutes of the meeting, then your lordship will have to go into an interpretation of what is the project and what is the premises. And as I showed your lordship, either it is to be read as completely distinct and separate expressions, or in the event your lordship takes clause 13 and your lordship reads it in a manner that makes the two interchangeable, even then, Lord, it's a triable issue. But not in my respectful submission, sufficient, Lord, prima facie case as he made out to show Lord, at least sow doubts with regard to Lord, the lack of transparency in respect of the transaction, the fact that there are attempts being made to deprive statesmen of its rightful dues. Lordship remembers the Shalini transaction. Shalini Gujarat transaction was about 350 crore. 393 was with 291 crores. 291 crores. This transaction is 235 crore. And the amount that we have been offered as our share, as Mr. Chidambaram argued, was only 32 crore after making deductions, which shows that the transaction which has taken place, although purportedly ostensibly appearing to be at 235 crore, actually is for much less. They've annexed a sheet which shows deductions on various heads, and ultimately I'm to get 32 crore. It appears to be a circuitous process of two parties coming together to deprive me of my rights in the property. In my respectful submission, these are issues which have to be decided at the, if not at the trial, at least at the hearing of the injunction application. And apart from everything else, if your lordship is with me with regard to the parking space, which is the largest independent open space, then not on the face of it, not the entire transaction between defendant number 1 and defendant number 2 will fail, because that could not have been transferred. apart from the rights I have to have the property revert back to me in respect of the various leases, including the lease with Trent, which is west side. If your lordship will permit Mr. Dutt to explain the accounts of this, because he was there. Just
Only one thing, I'll just take 2 minutes of your lordship's time. My lord, along with the conveyance, my lord, they have forwarded us a sheet of expenses. Kindly, my lord, see page 377 of your lordship's brief. This, my lord, I had tried to. My lord, here is a sale that is taking place where the conveyance stamp duty assessed was 1 crore 64 lakh, 16 crore 54 lakh. 16 crores.
Yes.
And this entire stamp duty was paid by Merlin. It was not paid by Hatishala. And that entirety of the stamp duty, my lord, is being deducted from the sale proceeds on my account. This is one. If the sale had taken place at a stage where, my lord, there was nobody except these two persons, one Trent and another here, there is a brokerage of 7 crores. And, my lord, other charges, and it ultimately boils down to 32 lakhs and all. So the 32 crores. So, my lord, I don't want to repeat. I just wanted to show this, my lord, that the person who was going to purchase the property, A, as on that date, did not even have the share, the value of the share, my lord, to even generate this amount of money, number one. We had alleged that this money was routed through Merlin. That's their allegation there. And I think, my lord, on affidavits, we can justify that. Number one. Number two is this, my lord, he doesn't even have the, my lord, capacity to pay even the, this conveyance, at the, my lord, one additional, this conveyance was presented twice. It was presented once in March 2025, my lord, when it was assessed. And there is an order of the assessor collector assessing that. Thereafter, they withdrew. Then in 2025 May, my lord, all of a sudden this company changed hands. And the share capital was introduced to bring up the share. Monies were brought in. And these are all available on documents which we have disclosed before the learned single judge. That this is a circuitous way of, my lord, trying to take possession of the constructed area, which he did not have under the development act.
That's it.
I'm
Such huge figures boggle my mind. 235 crore. Normally in these matters, we appoint amicus curiae who would be able to deal with such figures. So we can't even request Mr. Ratnanko Banerjee because he's on your other side. He's used to such figures.
He is.
No.
This also
Milord,
boggles my
may I
mind.
just say something, Milord? It would not be a problem for Mr. Banerjee.
Are you on my side or you're
Mr. Chaudhary did not like it that his name was not taken
No,
up
no,
with
no,
Mr.
no.
Banerjee.
Not qualified. Mr. Chaudhary is not qualified.
Accustomed to these figures on a daily basis.
Very well. Hearing is concluded. Judgment is
You
reserved.
just have 1 minute for the after Mr. Banerjee for the
Milord, that
chart
order
which
of
was shown. I just want to bring it to your lordship. Yes.
Milord, that order of the collector, Milord, which I just referred to, is part of the conveyance and part of your lordship's papers at page 410. It clearly says, Milord, that the value of the property, it was presented in March. Thereafter, Milord, it was returned. And in the present was by Hatishala only, through Hatishala only. Thereafter, it was returned because it did not have the capital, Milord, money. And thereafter, the...
All right.
Milord, accounts, Milord, which Mr. Dutt, Milord, placed would show your lordship.
You are Merlin or Hatishala?
Merlin.
Both.
No, don't confuse me. I'm Hatishala.
I know
Mr. Banerjee is Hatishala. Your lordship would see, Milord, the deductions. It's, Milord, for all the loans which, Milord, he's agreed, he's taken from me and he's agreed to pay me back from the sale proceeds in the 10th May document. So those, Milord, are essentially deducted. Apart from the usual brokerage, it's nothing else. These are monies which he's taken money to get the property free from SBI. He's taken money from me to pay off creditors, workers, the whole world who went after his property because he owed them money. He's, my lord, had me put in money and develop the property. Now when the property is developed, he wants to, my lord, get the purchaser's money in and block his money as well as all the money which I have put in after specifically agreeing to this sale.
Very well.
And one Lord, it seemed I just 277, which my learned from that's a dispute between them with regard to how much money someone's going to get from the other party. That can't stop the question of my putting in money and by me getting the property.
What is your business? You deal in elephants? No.
I don't know whether I keep elephants or not. Atish Chala.
This is the elephant, the elephant in the room.
It is into buying land and developing. It's a developer. And this is, I don't know why
It's concluded from judgment is
learned friends keep saying mortgage because this is not a mortgage, sale.
Then why did you
Not a mortgage. The land was mortgage to him. That's how he released the mortgage when he came.
We haven't ruled in terms of
promoters.
But we had relied upon the judgment but couldn't give the photocopy earlier.
Yes, yes.
And that's what you should.
Lord, I don't know about your lordships. We still take statesman, and depending upon your lordship's order.
This is not in circulation.
No. Even today I've got it. Even today I got it.
Apart from my e-paper.
Even today.
It is.
I think e-paper.
No. Because High Court also takes it.
Even no, we still take it.
Only special people get it.
But the quality of the paper.
Yes. And the printing has become great. And depending upon your lordship's judgment, we can decide whether to take
no more interest in reading because
you are developing your premises now. You want to run the paper.
There was a huge statesman house in Connaught Place in Delhi, if I remember.
That was at Barakhamba Road.
Barakhamba Road.
Yes.
They have used the same format over there. They now have a small flat which they rent out, my lord, as a office.
Oh, they have
Same format as, my lord, this. Get somebody to develop and, my lord, sell.
Very well. Let's.
Grateful.
Daku.
It's my appeal, my lord. Here, my lord had called for reports regarding, my lord, the quantum of money which is still lying in
Yes, I'm for the respondent.
the report.
Oh, Mr. Medora is leading
Yes. I'm led by Mr.
There were 3 deposits which were there. One 8 lakh, which was not interest bearing.
So essentially what transpires, what appears, if I've understood correctly, initially 13 lakh was deposited, 10 lakh was paid to Shining Vyapar, as per Supreme Court's order.
Yes. That's the
3 lakhs was supposed to be paid to Bhasha Construction,
like, my lord, the appellant.
but Bhasha never collected it.
We never
So that has been lying with the registry in a PL account, no interest.
So, my lord, 11 lakhs in now.
That's 3 lakh.
3 lakhs.
Then 3 lakh was deposited pursuant to Justice Mukherjee's order. That was invested. That has now become, as on 29th August, it has become 5.27 lakh. And another 8 lakh was deposited pursuant to Justice Showmanshin and Justice Kapoor's order. Again, because there was no specific direction for investing, that is lying there. So 8 and 3, 11 and 5, 16.27
My learned
roughly
friend is adequately secured.
is lying.
Yes. Today, my lord, as per the decree, it would come to roughly about 18.5 lakh.
Sure.
That is number one, my lord.
The principal sum is 3 lakhs, the decree. The rest is 24%.
It is interest which has accumulated till the date the decree was pronounced. So that forms the decretal amount.
Deposit 2 lakh more. We will firstly we'll direct investment of these amounts which are lying in the PL account without earning interest, and deposit the difference about 2 lakh. That will also be invested.
Maybe in the form of bank guarantee, if 2 lakh possible. Give us the option, my lord, in case bank guarantee or else cash, my lord, whichever, my lord, can you give us
Yes,
the
Mr. Madura, let that be so. 2 lakh, you
To your
are
lordship.
sufficiently protected, substantially protected. Issue.
Just two small submissions, my lord.
Yes.
I had indicated on an earlier occasion that a review application of mine is pending against the decree. There's a review which is pending, filed by me.
Acha.
So just 2 points, apropos that review. One is, my lord, if your lordship is granting stay, which is what has fallen from your lordship, the review should not be affected.
Yes, why should it be? It should
That
go
will
on.
kindly clarify
We
that.
will clarify that.
And number 2 is, my lord,
Hmm.
assuming I succeed in the review, then the sum which I'll be entitled to will substantially increase. So at that point of time, lordship will kindly leave it open for a further deposit to be made.
It was your suit.
No, my lord,
Because
it was
my counter,
my
his suit,
Your
my counter
counterclaim. His claim was rejected. Your counterclaim was
counterclaim was
partly allowed. Your counterclaim was partly
Partly
allowed.
allowed.
So therefore the review.
Yes,
Therefore the review.
that's right. Only
Instead of an appeal, a review.
yes, because there was an error in calculation. So that's an error on the face of the record.
only thing.
And
my
this
lord,
is your stay application we are
the
hearing.
application of the decree.
Hey, thou,
Only thing, my lord, in case my lord stays
memota thou.
the decree, my lord, how far the review of that same decree, well, that will alter the decree also.
Yes,
So, but how far the review can be proceeded with in case the decree is stayed in its entirety?
which is why I'm making the submission.
We'll say stay of execution.
Stay of
Yes.
execution.
That will suffice. I
That will, correct.
And I'll be, my lord, entitled to take all the points in the review in respect of
Everything is open. Everything is open. You are Mihijam.
I am
I am
No.
Mihijam. I am Mihijam.
I am shining and
Oh,
lifeline.
you are Mihijam, you are Bhasha.
Mihijam.
Both. You are shining.
Shining and lifeline. Car favor hai kya cheta? Counterclaim.
Both of which you are.
I hope I have a longish second one. I can bring my hand in front to determine.
This appeal is directed against a judgment and decree dated July 7, 2025, passed by a learned judge of this court in CS Com 788 of 2024. Stop. By the impugned judgment and decree, the learned single judge rejected the claim of the appellants who were the plaintiffs before the learned judge. Stop. The learned judge allowed, partly allowed the counterclaim of the different numbers 1 and 2.
Defendant number 1.
Of the different number 1. Stop. Paragraph. We recorded in our earlier orders passed in this appeal that certain sums of monies were deposited from time to time by the appellants pursuant to orders of court. Stop. We called for reports from the registry as regards the present status of such deposits. Paragraph. Today, a fresh report has been filed. Fresh report dated September 7, 2025 has been filed by the learned registrar, original site. Hey, September 1, sorry, কি বললাম 7 না এটা কি 1 না 7 প্রিন্ট করা আছে 1 1/7 করে এটা 7 মনে হচ্ছে দেখে 1/7 September 1/7, 2025. Stop. From that report, it appears that initially a sum of rupees 13 lakh was deposited by the appellants pursuant to an order of the Honorable Supreme Court. Stop. As per the direction of the Honorable Supreme Court, a sum of rupees 10 lakh was paid to the defendant number 1. Stop. The balance sum of rupees 3 lakh was to be paid to the appellant number 2, the plaintiff number 2. Stop. However, the said plaintiff never collected such money. Stop. Therefore, the sum of rupees 3 lakh has been lying in the PL account, to the credit of the suit, without earning any interest. Paragraph. It further appears that subsequently, pursuant to an order dated March 31, 2016, এই সুপ্রিম কোর্টের অর্ডারটা যেখানে বলেছি না ডেটটা দিয়ে দিন তো সুপ্রিম কোর্টের অর্ডারের ডেটটা July 10, 2013. July 10, 2013 passed in civil appeal number 8258 of 2013. Add করে দেবেন ফেরত আসুন কি বললাম কি বলছিলাম
It further appears that subsequently, pursuant to an order dated March 31, 2016,
passed by Honorable Justice I.P. Mukherjee, on April 12, 2016, a sum of rupees 3 lakh was deposited with the registry. Stop. That sum was invested in a fixed deposit account with the Central Bank of India, Red Cross Place branch, Kolkata, in terms of the direction contained in the aforesaid order. Stop. As per bank statement dated August 29, 2025, the said sum has now become rupees 5,27,067. Stop. Paragraph. Thereafter, in terms of an order dated February 26, 2019, passed by a coordinate bench in this appeal, that was passed in this appeal.
Malad, not in this appeal, Malad. This was.
No, it can't be. That was passed.
APO number 401 of 2018.
Passed in APO number 401 of 2018. কিভাবে করলাম এটা শুরু করলাম
passed by a coordinate bench in APO 401,
a further sum of rupees 8 lakh was deposited by the appellant with the registry on March 13, 2019. Stop. However, the report of the learned registrar says that in the absence of specific direction upon the registry for investing the same, comma, the said amount is lying with the registrar's PL account maintained with the Reserve Bank of India, comma, Kolkata, comma, without earning any interest. Paragraph. Therefore, we see that in all a sum of rupees 16,27,067, comma, deposited by the appellants from time to time, comma, is lying with the registry of our court. Stop. The decree that was passed on the counterclaim of the different number 1 is in the sum of rupees 3 lakh.
3 lakhs principal amount with the.
What is the decretal amount?
And that it works out to, my lord,
83,754 plus
16,83,754 plus 1.5 lakh as costs. So aggregating, my lord, 18,33,754.
18,13,000.
33,000.
That is with the cost also.
Yes.
That is with the cost.
Appellants করবে। না কেটে দাও। The decree that was passed on the counterclaim of the different number 1, comma, we are told by learned counsel for the different number 1, comma, would be in the sum of approximately rupees 18.30 lakh, 18.30 lakh as on date, including interest and costs.
Interest is not as on date, but as on the date of the decree.
As on the date of the decree. That sum you are saying is
as on the date of the decree. Decree কবে কাজ? 7th July. Yes.
7th
আচ্ছা।
July. Yes.
তাহলে as on the date of the decree করো, as on date করো না, as on the date of the decree. Stop. We direct the appellants to furnish security for a further sum of rupees 2 lakh, either in cash or by way of bank guarantee to the satisfaction of the learned registrar, comma, original side. Stop. If such security is furnished in cash, comma, the same shall be forthwith invested in a fixed deposit account in any nationalized bank. In the nationalized bank which offers the best rate of interest. Stop. If such security is furnished within a fortnight,
after 1 week,
within 1 week after summer puja vacation, না তার আগে লেখো, এটা কেটে দাও। Next লেখো. There will be an unconditional stay of the decree, judgment and decree impugned in this appeal for a period of unconditional stay of execution. Unconditional stay of execution of the impugned judgment and decree for a period of 1 week after the puja vacation, bracketed date দিয়ে দাও, October 31, 2025, bracket close, stop. In the event security of rupees 2 lakh, additional security of rupees 2 lakh is furnished by the appellants within that date, comma, the stay of execution proceedings shall continue till the disposal of the appeal. Stop. In default of furnishing such security, comma, the stay order shall stand vacated automatically. Paragraph. Insofar as the amounts lying in the PL account of the registrar, comma, original side, comma, maintained with the Reserve Bank of India, comma, are concerned, comma, The said sums of rupees 3 lakh and 8 lakh respectively, comma, shall be forthwith invested in the same nationalized bank where the amount deposited pursuant to Honorable Justice I.P. Mukherjee's order has been invested by way of fixed deposit. Preferably same nationalized bank. Or sentence
So far as the amounts lying in the
are concerned of the chole esho, are concerned.
the said sums of rupees 3 lakh and 8 lakh respectively shall be forthwith invested in the same
Preferably the same nationalized bank. By way of fixed deposit. সেম ন্যাশনালাইজ ব্যাংক মানেটা কি হতো? তারপরে বলেছিলাম তো
but the amount deposited pursuant to Honorable Justice by way of fixed deposit.
পুরোটাই থাকবে স্টপ হয়ে গেল তো। The fixed deposits shall be kept renewed from time to time and shall abide by the result of the appeal. Paragraph, the stay application stands disposed of. You have to file a paper books. Stop. Paragraph, let requisite number of informal paper books be filed by the appellants, incorporating therein all papers that were available before the learned single judge, comma, within 2 weeks after the puja vacation. Stop. All formalities are dispensed with. You represent all the respondents.
No, my lord, only 1 and 2. 3 and 4 are not really concerned, I would think. They had appeared.
Issue notice anyway, issue notice to them. Formalities dispensed with. Stop. Since the respondent numbers 1 and 2 are represented through learned counsel, comma, notice of appeal is deemed to be waived insofar as those respondents are concerned. Stop. Issue notice to respondent numbers 3 and 4. Paragraph lists the appeal under the appropriate hearing 3 weeks after the puja vacation.
Just 2 lines with regard to, my lord, that review.
Yes. Paragraph, we are told by Mr. Medora, comma, learned counsel representing the respondent numbers 1 and 2 tells us that insofar as part of the claim of the different number, part of the counterclaim of the different number 1 was disallowed, comma, the defendant number 1 has filed an application for review of the impugned judgment and decree. Stop. We clarify that pendency of this appeal or this order shall not stand in the way of the learned single judge deciding such review application in accordance with law.
My lord, in the event I succeed in the review, my lord, then your lordship will once again consider whether further security has to be given.
But you can always come back. You don't need liberty for
I will come up in appeal against that order.
Then for stay at that point of time, I make my submission.
এই অ্যাপ্লিকেশনটা হয়ে গেল। একটা লিখে দাও খালি পেপার বুকের ওখানটা, ডিসপোজড অফ যেখানে বলেছি, দিস অ্যাপ্লিকেশন স্ট্যান্ডস ডিসপোজড অফ বলেছি তো একটা জায়গায়, ওইখানে স্টপ। হাউএভার a copy of the stay application be included in the paper book for the sake of reference.
Grateful, my lord.
Grateful, my lord. Deeply obliged.
Item number 4.
But this arises out of an application, not under Section 9, where not we had a interim order protecting our rights. That has been partly not brought down, the amount of security. The appeal is against that. Not very limited scope, not before I take your lordship into the order, I'll just point it out. But there is a secured loan of 26 crores given by SRE to the respondent, not which is called Trinity. Secured loan, the charge is registered with the MCA website.
What's the
Security.
security?
Not security are shares and not other assets like that. So the value of that comes up and down, and the agreement provides.
Mr. Bachavat,
yes,
you are also in the Rampur matter.
Rampur. Oh, Ramsaru.
Ramsaru, sorry.
It's pointless time. It won't finish this side of the vacation.
That's right. So, shall we? Has Mr. Mukherjee concluded?
Yes, he has. I was to
start.
Yes, I was to start.
You want to start, or you don't want to? What should we do?
But it's pointless. It's going to spill over.
No, otherwise, Mr. Mitru is waiting. Mr. Joyantu Mitru will release him. If you say that matter will be heard, then nothing else will be heard.
But pointless. It won't finish this side of the
other side.
I'll speak to him. Just have a word with Gopal. Have a word with Gopal. Oh, he's here.
Yes.
Mr. Banerjee.
Decide between the two. You have to please decide.
The only thing is, we still don't have water.
You decide. We are here to hear you.
But he is not someone who drinks water only.
This
much I know.
If you tell us that it will be taken up, we'll release Mr. Mitru then. But if you don't do it, then...
No, Mr. Bachavat has to do it. We are here.
Right.
Mr. Mukherjee also has
But
to
I'm very clear, but it's not going to finish in one day. It will take about 3 days. I can start.
Then do it. Then we'll release Mr. Mitru. Why?
You can do that. Again I'll start afresh.
Unlikely that gas matter.
Yes. Then, my lord, I was making my submission, so lord, I'll have to continue with my
336.
If it is taken up, it will be taken. Mr. We can't say Mr. Mitru because
If it is taken up, it won't be taken up today, perhaps.
very unlikely.
Very unlikely, because at 3:30 your lordship.
3:30, if it is taken up, Mr. Bachavat will take 10 hours.
Lord, I'm being candid with your lordship. Lord, I can start off now, but not in a month's time. Everyone would have forgotten. I'll have to start afresh. Nothing more. Lord, it's just that. Practical reasons. I am ready to earn a fee. I have no problem.
This is where you have to decide this with
Lord,
Mr.
if my lord wants to make me finish GCL, my lord, I can do that. I'm also ready to do that.
Be practical.
I can finish, my lord, my hearing,
Which
but
one?
then, my lord, Mr. Mitra, my lord, will the gas. Then, my lord, Mr. Mitra will have to.
No, then do
reply.
you choose between Rampur and gas.
Lord, he's good at gas.
The 6. GCL or
I am
7.
Mr.
GCL
Bose
or
and I are lower down in that line than item 6, which was taken up the other day. But Mr. Shaha was not present, your lordship remembers. Yeah.
Wondering after today, if it is not taken up today,
Friday.
the Friday,
Friday.
Friday is no day.
So very generous of your lordship, Lord.
Friday is no day.
Because it's commercial. Commercial is Mondays and Fridays.
Friday, my lord, I don't think, my lord.
So shall we clear all confusion and say immediately after vacation?
Whatever, my lord, I'm always, my lord, I'm ready. I want to do any.
That will be practical thing.
Lord, I think. But it will also leave time for the smaller matters, Lord, which can be finished during that time.
Very well. Then we item number 7 immediately after vacation. But 3:30 then
put it after the vacation, Lord. It's pointless.
It's anyway, my lord, part hard, and my lord, I think,
Yes.
my lord, it's especially.
It's assigned. It's assigned. Shouldn't be a problem.
No, no,
No,
আমাদের part.
Oh, part.
Arey, it's
G
scale. Not Ramthur, not Ram. What are you assigned, no?
7, yes.
To both my lords.
Then,
my lord, it.
Then, soon after the vacation, whenever you.
Immediately after the vacation.
24th.
Very well. You carry on with this.
Yes. Yes. So, my lord, secured loan of 26 crores. Wait.
That's not good. तेरा टुकड़ा आता है जो टुकड़ा रख लेना गैस जल बोलने में मुझे
Yes. Lord, I've lost track now. Bloody.
25 crore or
Yes,
something.
26 crores secured loan. Not the agreement provides that in the event of the value of the securities falling, they will further furnish further security. Now, not the long and short of it is, not the petitioner company not went into insolvency on an application by the Reserve Bank, saying that the petitioner's business was not being conducted properly. Ultimately, a scheme was formulated and it was taken over by a company called NARCL, which is not owned by not public sector banks, mutual funds, etc. So, it comes into the picture and then it goes out to recover these dues. Now, the agreement provided for repayment at the end of 2 years, along with interest at the end of 2 years. There was no interest or anything payable during that time. So, we applied because their balance sheets and the audited accounts that they gave showed that the value of the securities had fallen to about 12 crores. So, based on that, we applied. The claim at that point of time was about 53 odd crores. Now, given the difference, that the securities were 12 crores, the injunction was passed against those securities and against the bank accounts to the extent of 40 crores. So, this is the interim order which we are enjoying. Now, at the final hearing, a part of that interim order.
Which commercial court is this?
No, our High Court.
Oh, our High Court.
Our High Court, Section 9. Now, that's the order which we are enjoying. Now, on contest, that interim order was not continuing on contest, not that it was ex parte or anything like that. Now, then, on a final hearing, the portion of the order which related to injunction on the bank accounts has not been vacated. Now, it proceeds on a principal fallacy, which is this. Since I had gone into insolvency, the learned judge has proceeded on the basis, look, my claim must be a part of whatever scheme was framed by the in insolvency. Either it's there or it's not there. If it's not there, that claim has vanished. That's the basic fallacy. It's a point argued by no one. None of the parties argued the point. Notes of arguments are on record. I'll show that to your lordship, and I don't think my learned friend will not dispute it. The principal fallacy is not in a scheme, it's the creditors, it's a scheme taking care of the claims of the creditors. So, if anything, creditors' claims are wiped out, not debtors' claims. The interim order has been vacated on the basis that, look, it is not, it must be covered by the scheme. If you have not got it under the scheme, it's gone. Not realizing that a debtors' dues are not covered under the scheme at all. So, this is one part. I'll just point out 3 points and I'll take your lordship straight to the order. Second point, is this. If it's not covered by the scheme and it's got extinguished, as the learned judge says, then the interim order couldn't have been continued even on my claim of 26 crores. Second point that the learned judge says is, look, it's gone under the scheme. Now, the acknowledgement that they have is for 26 crores, which is the principal amount. There is no acknowledgement for the interest. Therefore, I retain your claim to the extent of not the principal only, because there is no acknowledgement. And the acknowledgement says 26 crores on account of principal, there is nothing about interest. So, these are the two problems there. I'll just point out.
So, the injunction restraining them from operating the bank account, excepting without leaving 40 crore, has been whittled down to without leaving 14 crore.
No, whittled down to nothing on bank account.
That's gone.
On bank account and left to the charged assets, the value of which, according to the balance sheet they had, was 12 crores. Now, in the course of proceeding, they filed something to show that that has now miraculously gone up to 40 crores, still a shortfall. It has gone up because the value of one particular security, according to them, has jumped up 300 times. I'll show that. But the basic fallacy is this. May I just take your lordship to the impugned order once minute? There is no dispute about the 26 crores. Just keep that at the back of your lordships, not mine. No dispute on 26 crores. Now, if your lordship would take the impugned order, the findings start at para 19. No, I'm sorry. 23. At page 12 of the impugned order, in the memo of appeal. I don't think I'll have to show your lordship very much from the petition because it's all noted here. Heard learned advocates for the respective parties. Question is whether the interim order already passed should be vacated or continued and what reliefs are available. The fact that 26 crores was lent to the petitioner is an admitted position. So admitted amount was reflected. Not, I'll skip that portion. That letter is set out. If your lordship not then turns the page, your lordship will find the second finding in para 24. Contention of Mr. Shah that extension of loan was actually an investment by SIFL in its erstwhile wholly owned company Trinity shall be decided by the arbitrator. So that goes against them again. Question involves admissibility of the claim. Further contention of Mr. Shah that an undertaking was given by SIFL in a proceeding before NCLT to the effect it would not take any coercive measure against the respondent is again a matter of evidence which is to be decided by the learned arbitrator. There was no order or anything not saying this. However, from the deeds of hypothecation, now please see this, this court finds that all investments, present and future, were secured in favor of the petitioner. So, my lord, finding that there is security of all investments. Schedule does not mention exactly what the investments were. No specifications were provided, which means that all existing investments held by the respondent at present or to be made in future in its own name would remain charged with the petitioner. No other form of security has been provided in the deeds of hypothecation. The schedule does not provide any further charge. Now, my lord, this is where they first go wrong. The schedule naturally, my lord, contains the charge. The further charge is in the agreement. It says if the value of the security is dipped, then it has to be replenished. The schedule does not provide any further charge. What would happen if the value of investments depleted has not been provided for? So this is not the first error. This is the first error. The argument of Mr. Bachawat that as the value of the investments has depleted, further security would be provided is not accepted. Lord, I'll show your lordship the clause. Can I take your lordship straight to that clause? Please take page 110. Of the petition, volume 1. Page. Your lordship will find Article 3 at page 110 with the heading security. The obligation of the borrower shall be secured by way of, and if your lordship goes to 3.2, the security stipulated in 3.1 shall be created in the form and substance satisfactory to the lender. Security stipulated in 3.1 shall be created and perfected by filing forms, which was done, my lord, as applicable with the Register of Companies. Then, my lord, please come straight away to 3.4. If at any time before final settlement date, the lender is of the opinion that the security provided by the security providers become inadequate to cover the obligations, then on the lender advising the borrower to the effect with a notice, borrower shall immediately provide and furnish in favor of the favor or benefit of the lender to the lender's satisfaction such additional security as may be acceptable to the lender, etc. I won't trouble your lordship with the rest of it. Lord, it keeps on not giving further details of it. So the agreement specifically states that the shortfall in security is to be made up. Now, my lord, going back to the impugned order, my lord, page 13. Lord, going back, the argument of Mr. Bachawat that as the value of the investments are depleted, further security should be provided is not accepted. Court need not pass directions for securing the alleged sum calculated by the petitioner at present. The petitioner is entitled to protection of what was charged to the petitioner as per the deeds of hypothecation. However, the letter quoted above mentions that as per the books of account, 26 lakhs was payable. It says principal. The petitioner did not object to the quantum mentioned. Thus, in my prima facie view, the petitioner's claim that an amount of 53 crore 61 was payable at present is not supported by any admission. Now, my lord, please just look at that document. Lord, if your lordship will take first, Lord, page 216, which is that letter, that will be volume 2. Now, my lord, please see what it says. But this is their admission as on 23rd April 24. Page 216. We hereby confirm the outstanding on 31st March as per our books of account payable to you, principal due 26 crores. The above amount does not include any other charges or interest due on the mentioned date. And I'll show your lordship that not as per the agreement, my lord, interest was not payable monthly or quarterly, but at the end. So that's the reason it was never calculated. So 26 crores is the admission. ওই agreed interest 12% টা কোন কথা ছিল বলো? ওই schedule এ ছিল বলো? 114. 149. But if your lordship would just go back to page, not volume 1, page 149, or if your lordship need not, specifically says interest at the rate of 12% per annum is payable, not at the end. Your lordship can make a note, 12% payable on maturity.
Page 149.
149. Applicable interest rate shall be 12% per annum. Interest shall be payable on the maturity of the loan. And borrower shall pay applicable interest tax, other levies, duties, if any, over and above. Which is why the letter said it does not include other items. Now, my lord, to go back to the impugned order, I'm sorry, my lord, I'm making your lordship not go from one thing to another, but that's probably the shortest way to finish it. Then, Lord, thus in my prima facie view, the last 3 lines. The petitioners claim that an amount of 53 crores 61 was payable is not supported by any admission. As per the, they've admitted the principal and the interest is admitted. So, Lord, it's just a matter of calculation. That calculation has not been disputed by them. As per the petitioner's estimation, the investments mentioned in the application was worth 12.41 crores. Further investments have been disclosed in the proceedings, which have been valued at 41 crores. Although these disclosures have been stated to be unreliable, in my opinion, the petitioner has not been able to establish with proper calculation that the investments which have been disclosed are not worth 26 crores. A further deliberation probe by this court would amount to a mini trial. Value of the investment depends on the market condition. Now here, Lord, may I show your lordship, Lord, what their document showed? It showed 11 point odd crores. Lord, I'll just show your lordship that document. Volume. Page to all But please take volume 2, page 258. Now, my lord, if your lordship comes to page 258, this is extracted by us from the documents that they have given us. And if your lordship sees, I know I'm being not very short, but not if your lordship sees the third column, the total at the bottom. 12 crore 41 was the total value of all the securities according to them. So we had proceeded on this basis. After that, we wrote several letters, which are at page 259 onwards, series of letters, not asking for details, which they did not provide. Series of letters. Now, but it's in this background, we proceeded on the basis of the figures given by them. Now, when they filed their opposition, also, they don't disclose anything to the contrary other than saying that these are securities which belong to third parties. Then, a supplementary affidavit is filed by them indicating that the value of these securities has miraculously jumped in a few months from 11 crores to 40 odd crores. And out of that, not the value of all these other investments shown in not page, the page which I showed your lordship, remains the same. Value of only one security not jumps up, something they call Bharat Nirman, not jumps up manifold from 5.8 crores to 1.8 crores, which your lordship has found over there, to 38 crores. So there's a 30-fold jump in the value of this investment supposedly. So this was the situation. Now to go back to this, to go back to the impugned order. A further deliberation. So these are not the only grounds. Now please see what happens after this. There is nothing on record to show the alleged reduction of value of assets was attributable due to any malafide conduct of the respondent. Significant factor before this court is that SEFL was 100% owned subsidiary of SIFL on the date of the loan. Then Trinity was also 100% fully owned subsidiary of SIFL. Thus, in effect, SIFL had lent money to Trinity, which was owned by SIFL. Thereafter, SIFL sold 49% of the shareholding in Trinity to Payesh. Till date, SIFL is the majority shareholder, owning 51% of shares in Trinity. So, to give your lordship the picture, SIFL and SEFL, they held this respondent company 100% shareholding. Then, someone called Payesh came in and purchased 49% of the shares. Having done so, they obtained control of the company without having majority shares. And they said, we will not pay this. They came in the way of repayment of this. This is what that whole game is about. Now, nothing thereafter turns on this. Then, the next major portion, if your lordship comes to page 27, and this is where the judge goes completely wrong. Page para 27. I'm sorry, para 27 at page 15, in a page 15. Now, if your lordship goes about 7 lines from the top, sentence beginning with respondent is a fully functional entity. SIFL has 51% shareholding in Trinity. It is a fact that NARCL manages and controls and administers both SIFL and SEFL. SIFL is a majority shareholder in the respondent company. Now, please mark the next line. The resolution plan of NARCL was approved by NCLT. Now, this resolution plan related to stray companies, not to Trinity. Just bear that in mind. And the petitioner's claim as that of a financial creditor ought to have been included in the plan. Could not have been. But the petitioner was not a financial creditor of Trinity. Trinity was not under any resolution. So there was no question of anything being included in that plan. What is included are the claims of the financial creditors of stray companies. The petitioner was not included in the committee of creditors, but being a related party to SIFL, was allowed to represent, participate, vote in the meeting of committee of creditors of who? Stray. The alleged debt which the respondent owed to the petitioner should have been factored in and included in the claims of the financial creditors that has been admitted. Now, I can't be a financial creditor of myself.
Resolution plan was for SEFL or SIFL?
Both. But both were taken over by a company called NARCL, which is National Asset Reconstruction Company, which is owned almost entirely by Unit Trust of India, banks, public sector banks, etc. However, parties have not produced the plan which would have dealt with this aspect more in detail. After resolution plan was approved by NCLT, the dues payable to the petitioner as per the books was 26 crores, was communicated by a letter of so-and-so date. The possibility that only 26 crores were admitted in the resolution plan cannot be ruled out. But none of this can be in the resolution plan at all. Resolution plan had nothing to do with Trinity. Then, the order is set out, and if your lordship turns the page, please see the impossibility over here. Para 83 of that order contains a list of the members of the committee of creditors. These are all banks. These are dues of the bank. Then, para 85, please see, financial creditors, the total amount of their admitted claim is mentioned. Obviously, this can't include raised claims over Not SIFL or SEFL's claims. That's not relevant to this. So, this had nothing to, therefore, the Lordship sees the amounts given, it has nothing to do with Trinity. Then, please see the finding, para 29. Whether the petitioner's claim was included in the amount of 32,749.26 crores in the claims of the financial creditors is an issue which will be decided by the learned arbitrator. Now, but this could never have, my claims could never have been part of it, and this is why the learned judge has gone not wrong. And not to be fair to the other side, they did not argue it either. They did not argue this. Yes.
You have to be fair to your Rampur friends. Mr. Mujumdar is waiting. So sort out whether you'll do it or you won't do it. Mr. Banerjee is there. No.
36.
Parted to Achi already. It's already parted.
No.
Yes. Okay, what? Gopal Das.
Mr. Mukherjee, please have a word with Mr. Bachawat and tell us.
Anyway, this side of the vacation, I'm not going to finish now with. So, Yes, হবে না পাঠক করি না পাঠক করি এসব তো আর হবে না ঠিক আছে পাঠক But the understanding is that if your Lordship takes it up at 4:15, 15 minutes, if your Lordship makes it parted and keeps it after the vacation
This matter, my lord, if Exide was parted, my lord, we are both agreeing, my lord,
Yes.
this should be parted.
This should not. Your Lordship has heard Mr. Mukherjee in full.
And my lord, your lordship recall, there was another division bench. My lord, where, my lord, it had been heard substantially and then we've come.
But in fairness, your Lordships can make it parted.
4:15 we'll take it
Very
up.
well.
Yes.
But if I can just go back to para 29. Whether the claim of the whether the petitioner's claim was included in the amount of so-and-so in the claims of financial creditors, an issue which will be decided.
32,000.
It was huge amount of business. There was a
32,000 rupees.
Crores. These are the kind of figures Mr. Mukherjee and others deal with in NCLT. In the High Court, 1 crore is enough for our jurisdiction.
Yes, the heading doesn't say in crore or in lakh. It doesn't say so.
No, it is that.
Crore.
But this is one of those. But this is one of those exceptional matters where the RBI applied for insolvency on the ground that this was not being, these companies were not being run properly. So, after that sum, if the claim of the petitioner or part thereof was not included and admitted in the resolution plan, the same stood extinguished. Now, please see the effect of this. And if it stood extinguished, then why give me an injunction on 26 crores? Whether the intention of SIFL was to take over control of Payesh by using such coercive measure through SEFL is also a question which has to be decided by the learned arbitrator. Then, the NCLT order is quoted. Now, turn the page to para 31. Interim protection is granted upon consideration of prima facie case, balance of convenience, inconvenience, irreparable loss and injury to be suffered by parties in case of grant of or non-grant of interim protection. A prima facie case of the petitioner's dues of 26 crores is available from the books of accounts of the respondent. This is also admitted in the letter of 23rd April 24. However, balance of convenience and inconvenience and irreparable loss and injury tilt is not continuing with the is in not continuing with the order of injunction that was passed, restraining the operation of the bank account without keeping aside a sum of 40 crores. The fact that SIFL and SEFL are both owned, controlled, and managed by NARCL indicate NARCL has adequate control over the respondent. Now, here, my lord, one more comment to make. I have no control. Admitted position is proceedings are pending, not before the not NCLT, with regard to operation mismanagement and who's in control. There is a dispute about the control, although he has only 49% shares and I have 51% shares. He is not in the majority on the board, has been preventing holding of any meetings. NARCL's interest is protected. So how is it protected? Not if he's in control. The relevant portion of the order of NCLT is quoted below. On hearing submissions made by the administrator and on perusing the record, we find the resolution plan filed by NARCL has been approved with 89.25 voting share. As per COC, the plan meets the requirements of being viable and feasible plan for revival of the corporate debtor. It's pertinent to note that NARCL along with Indian Debt Resolution Company have been proposed to carry out compliances. By and large, all compliances have been done, etc. But not really relevant. But the order is quoted, and then, my lord, if your lordship comes to para 32. The injunction order under SARFAESI Act over all secured assets as per the schedule is sufficient protection. Balance of convenience is in favor of vacating the injunction on bank account. If the order of injunction is not vacated, it would amount to interference with the day-to-day business of the respondent. Thus, the interim order passed is modified to the extent that there will be an injunction on all investments which have been disclosed by the respondent in the 2 supplementary affidavits and also those that may be made in future. Respondent shall be restrained from disposing of, transferring, parting with, redeeming shares or units held in the investments and funds. This injunction will apply to all future investments. Order will continue until further orders are passed by the auditors, by the arbitrator. Audited accounts shall be handed over to the petitioner within 2 weeks. Respondent will be obliged to provide information, etc. And then, Lord, para 31, petitioner does not require any further protection. Petitioner at this stage is entitled to security as mentioned in the schedule of the deed of hypothecation. Respondent is continuing his business activity, is fully functional. Pleadings do not indicate the respondent has tried to remove its asset or alienate its property, etc. Now, my lord, here, my lord, now if I may just not formulate my points. Number 1, my claim is a secured claim. The security, my lord, the clauses provide oh, now you are here, not Joy. No.
Mr. Bachawaz, before you proceed any further,
yes,
this application was entertained by the learned judge in the sense that it was decided on merit when the tribunal was not available to you.
No, it was. It was. He had been appointed. Lord, in fact, Lord, that's part of the fun. Justice Sonji Banerjee was appointed arbitrator, and both my learned friends. I'll show your lordship that he was there. But
Matter is
both
fixed
my
for
learned
final
friends,
arguments
yes,
on 17th of November.
correct.
Oral
Now, in the
evidence has been
meantime,
concluded.
yes,
No, with an arbitral tribunal available to you and section 17 available to you,
yes.
why should we intervene?
I'll tell your lordship.
Paragraph 33.
Because the matter has now
liberty
gone
been
into
provided
arguments.
if your lordship
But
might
the
have
matter
seen.
has now gone into arguments.
Petitioner is
But
always at
evidence is
liberty.
completed. Evidence is completed. Now, if in the meantime, Lord, there are no assets, Lord, there is nothing which is going to happen.
No, we are saying go and approach the arbitrator.
But he is now into
Liberty is
final
given.
arguments. Lord,
They never made
that
an
stage is
application
gone.
before the no.
That
They
stage
never
is
made
gone.
a section 17
Lost
before
the
the
jurisdiction under section 17.
He's not.
Arbitrators have, the arbitrator has lost jurisdiction under
No, he
section
is not.
17.
I'm not saying that. I'm not saying that. Not at the
That
stage of
liberty
final
was
argument.
expressly reserved. If your lordship would
But,
kindly have
but the
paid
interim order has not.
23 once.
But my learned friend will have his say. But please see this. But it was the interim order of the court that I was enjoying. Now, that has been vacated long after the arbitrator had been appointed. I'm entitled to say, please put me back in the same position. That's all. Today, the arbitration will go off track if the court now again has to decide a section 17 afresh. It's now within this limited blood area. Hmm.
Yes.
But what is sauce for the goose is sauce for the gander. The arbitrator had been appointed, he was over there before the interim order was vacated. Then the learned judge should have sent it with the existing interim order to the arbitrator to decide. Instead of vacating.
Ideally so.
So, couldn't have vacated if that's the principle one is on. Now, I say at this late stage, at this late stage, you have a flight to catch, you go. Sit here. মাথাটা বাউ করে যাওগে দেখেন
Yes.
My learned friend has a flight to catch if your lordship succeeds.
All right. Happy vacation.
No, not vacation. Professional.
But money is more important to these. But there's been a lot of entertainment, I'm told, in the arbitration. But both Mr. Thakkar and both of them, Mr. Ghosh, have been the recipient of jhad across
the computer screen.
Across the computer screen, and he's loud enough to do it.
You did it virtually.
Because the learned arbitrator was hard pressed for dates, and he wanted to expedite the matter. So your lordship sees appointment in April, and now it's ready for arguments. He was willing to do it this side of the vacation. He said, please excuse us.
Somehow managed to make good the escape.
We completed the witness action on 16th or 17th of September. His lordship said, you do it, I'm available. Please excuse us.
But it's not just these two. I believe even the witness did not escape his.
Did you have the occasion to visit his lordship's residence in Shillong? Official residence? Did you?
Right. I happened to see it when we went for his retirement. Me and Mr. Bose had gone for his retirement. We went there.
I know somebody who went and had sandwiches, ham sandwiches and all.
Right. Can't be him.
No, can't be.
I see. I see.
Yes.
So the point is one couldn't have upset the apple cart at that stage where arbitral proceedings were on. If it had been done at an earlier stage, we could have gone with the section 17. But now, your lordship knows how fast this is proceeding. Now, to upset the apple cart at this stage and say now you decide a section 17.
All right. Yes.
So, this order has to be revived. Now, to formulate my point, number one, it's a secured claim. Now, it is not just a secured claim. It says that if there's a shortfall in security, that has to be made up. Now, there is a persistent situation where persistently they are asked to reveal what are these securities and they don't give it. They refuse to do it. Two affidavits filed, they don't show the value of the securities. We proceed on the basis of the admitted amount. And then they suddenly come up with something without any basis of backing, saying that this 1 crore is now worth 30 crores. One of these investments. So therefore, you've got well close to adequate security. So first secured. Number two, I have the right to demand that it is not brought up to the amount applicable. Number three, this is an admitted debt. Your lordship has seen 26 crores is being disputed by no one. Interest rate is being disputed by no one. The figure is not disputed by anyone. The learned judge proceeds on the assumption that, look, there's an admission for 26 crores only. Therefore, only 26 crores. And the real basis is, look, your claim has got extinguished, which is not a claim which not anyone will make.
Yes.
There are balance confirmations. His balance sheet has this amount outstanding. This claim is an undisputed claim. It's a secured claim. My securities have to be restored. But this is the simple situation. But there was an injunction on the bank accounts. But that has to continue.
Will you please show us the order?
Yes.
By which the
Yes.
bank accounts were?
Yes. No, that's at page 293. Volume 2. But if your lordship would come to 296, that's the operative portion. But at 296, second para, Panchnama and inventory issued by the authorized officer and communication of the authorized officer with regard to taking possession of the investments indicate there was non-cooperation and non-disclosure. Such conduct of the respondent prima facie indicates that protection is necessary to secure the dues. Injunction, which is already operative in terms of prayer A of the order passed under 13.4 of SARFACI remains. In addition, this court is of the prima facie view that a further injunction should be issued restraining the respondent from operating the bank account, which is with by ICICI Bank, without keeping a minimum balance of 40 crores. Bank shall ensure compliance, etc. And they were then directed to file an affidavit disclosing other assets, investments, and bank accounts, both past and current, etc. And nothing came. Now, one of the points which they argued is although it doesn't reflect in the order vacating it, this balance of convenience point, one of the points argued was, look, this is the amount there is not really funds belonging to creditors. Not creditors, investors. These are investors' funds. And therefore, injunction on the bank account is going to affect that. Now, our argument was very simply, it can't be, because not an investment manager or someone who operates like a mutual fund, which they claim to be operating as, does not hold clients of the client funds at all. But if I am to buy a mutual fund, I buy, I don't pay the broker the amount. I pay the mutual fund directly, and the mutual fund is sold to me. This is how it is. It could not have been funds of investors, and there was not a single letter from any investor saying, because this injunction has been there for the last 8-10 months, whatever, I am affected, or movement of my money is affected. According to them, this was the funds of the investor. There is no finding in their favor. Instead, the learned judges said very simply, balance of convenience is against. So the learned judges not found on 3 counts against me. One, admission only of 26 crores. There I point out, well, could have been admission of anything else. Number 2, the learned judges proceeded on the basis that either extinguished or by the scheme, which is a impossibility, and it was not argued by them. But I think, considering we are just before the vacation, I'll keep it within this.
So only 26 crore admitted. Number 2 extinguished. Number 3 balance of convenience.
This entire application, the ad interim order which was shown to your lordship at page 293 was an ad interim order without the affidavits. Directions were given for filing of affidavits.
Not ex parte, was it?
No, it wasn't ex parte. We were represented. It was without affidavits, and it was an ad interim order. And the learned judge was pleased to record their submission that the security which has been furnished appears to be inadequate at the prima facie stage. Now, clause apropos this, 13.4 of the loan agreement was shown to your lordship, my lord, my obligation to furnish security if the amount is depleted, if the value is not sufficient. And it was told to your lordship, my lord, repeated notices have been given, and one such notice was shown to your lordship. Kindly have the notice once, please, and kindly also see the clause once, please. No notice has been given to me till date. The notice which was shown to your lordship was a notice issued under section 13.4 of the SARFACI Act by the authorized officer and not by the petitioner in this case. The petitioner has not called upon me ever to say that the securities which you furnished are not sufficient to cover the value of my so-called loan, number
If
one.
they call upon you today,
No, my lord, kindly bear with me for a minute. Apropos that, my lord, the submission that what is sauce for goose, sauce for the gander, it could not have been vacated. It should have been sent lock and stock to the learned arbitrator to decide. Perhaps, my lord, I'm just pulling out the judgment, my lord. There's a judgment of the Supreme Court in ArcelorMittal, where the Supreme Court says that once a Section 9 is entertained and the court has applied its mind to the matter, then during the pendency of the Section 9 application, notwithstanding the appointment of the or constitution of the tribunal, the court retains jurisdiction under Section 9. It need not satisfy that test which is there, that you grant a relief which the arbitrator may not be able to grant, or it's not equally efficacious, then the court entertains Section 9. That test would not be applicable, because the court has already entertained a Section 9 and has applied its mind to the matter. Then the court will dispose it of. Today we are not at that stage. Today the tribunal has been constituted. This order was made, this judgment was reserved on 19th May. The tribunal was appointed sometime in the end of April. At that time, the Section 9 court was fairly in season of the matter. Several hearings were held, I'm told. I was not representing the respondent at that stage. Other learned counsel were. So, my lord, the matter had been sufficiently, progress had been made in the Section 9, and therefore the learned judge took it upon herself to deliver a final judgment. Today, my lord, the proceeding is different. This order was made on 18th of June. Today we are in 19th of September. 3 months have passed. More than 3 months have passed. The tribunal is on the stage of final arguments. In spite of the liberty granted by the learned single judge to approach the tribunal for further reliefs, no such application filed. The tribunal record, the court records, the learned single judge has recorded, my lord. May I just place, your lordship has seen that, but for my satisfaction, may I just place once, please, my lord. Twice it is recorded, not once. Page 22, internal page 22, paragraph 32 of the order impugned. This injunction will apply to all future investments to be made. This order will continue until further orders are passed by the learned arbitrator. And this is repeated at the last page, my lord. The petitioner is always at liberty to pray for interim orders. The arbitration has commenced and it is informed that the same has been fixed before the learned arbitrator in the end of June. The petitioner is always at liberty to pray for interim orders before the learned arbitrator. No steps taken.
Mr. Thakkar, once the High Court
Yes, please,
has whittled down the scope of the injunction order,
please, my lord.
Vacating the injunction in respect of the bank account,
Please, my lord.
do you think the arbitrator will pass an order?
My lord, the arbitrator, with
face
the
of it,
greatest
the
of
same
respect,
order?
my lord, with the greatest of respect, my lord, the arbitrator
Difficult.
in this would have the benefit of the pleadings before him, A, and that is something which has weighed on the mind of the learned judge also, because we raised several tribal issues. First being that this was not a loan in the first place. This was not a simple money lent and advance transaction. This was an investment by the parent company into my company through its another subsidiary. Both these companies, the petitioner as well as the respondent, were wholly owned subsidiaries of Shrey Infrastructure Finance Limited at the material time. And what is my business has not been told to your lordship, my lord. My business is investment in securities and managing alternate investment funds. That is my business. The sole beneficiary of my business is the common holding entity, which is SIFL. Sorry, mother. SIFL. This is SCFL.
This is SCFL.
This is SCFL. So this was a fund which was parked with the respondent for the purpose of deriving benefit ultimately for SIFL from the business of the respondent. And that is why the interest is never admitted. And my learned friend tells your lordship that the interest was to be computed at the end. The interest is shown to be payable after 2 years. And by the time I give this so-called acknowledgement of mine, that 2 years time had lapsed. But I never acknowledge interest, nor do I treat it as a loan. That is the entire defense which is there. I'll need to place, my lord, paragraphs of my vacating application, that this is not a simple money lent and advance transaction which will be borne out from the documents which I have appended. And that is my case in the arbitration also, that these documents were brought into existence to give it the color of a loan transaction. Now, the notice and the clauses which are shown to your lordship, before the litigant comes to court with a case that you have not furnished adequate security, he has a charge not only on the... Kindly see the notice, please, my lord, and kindly see the clause once which was shown to your lordship once, please, my lord. Kindly take the trouble of seeing the clause once, please, my lord, of the loan agreement. Kindly have, my lord, clause 13 point... Kindly give me a minute.
Security.
Sorry,
Speak.
3.4 at 110, please, my lord. If, may I place the clause, please, my lord? If at any time before the final settlement date, this is 2 years, my lord, from the date of the loan, so-called loan, the lender is of the opinion that the security provided by the security providers has become inadequate to cover the obligations, then, my lord, kindly see, on the lender advising the borrower to that effect with a notice, the borrower shall immediately provide and furnish in favor of, for the benefit of the lender to the lender's satisfaction, such additional security as may be acceptable to the lender within the time stipulated by the lender to cover such inadequacy. This is the clause. He has to call upon me saying the security which you have furnished, I'm sorry, is inadequate. You please furnish additional security. Now kindly see the document which was shown to your lordship, my lord. Kindly have 259, please. The notice. Kindly, this document starts at 255. And that is an extract from my management accounts, which are continuing for a period of time. That is not my audited financial accounts. 259 was shown to your lordship, my lord. This forms a part of, I'm sorry, 257 was shown to your lordship. This forms a part of the document which starts at 255, please, my lord. And this is a, kindly see, my lord, it's a notice under section 34 of the SARFAESI Act. This is a notice treating the loan as having been recalled. And this is not even a 13.2, it's a 13.4 at the second stage of the SARFAESI Act. And what it relies upon, my lord, kindly see 257, kindly see paragraph 1 at the bottom of that page, please. This is the figures as per my management accounts as of March 20, 2024. This is not my audited and final accounts. Paragraph 1, your lordship has, my lord, at the bottom of page 255.
Yes.
Kindly see, my lord, as per the audited balance sheets filed by you for the year ending so-and-so and the management accounts as of March 2024. These are not my final audited accounts. And these are legacy figures which are carried on forward by the management. And I filed, my lord, I manage, my lord, what is called as alternate investment funds, in which I am required to be statutorily invested to the extent of 2.5 crores or 2.5% of the value of the entire fund, or 5 crores, whichever is less, as per RBI guidelines. That is my statutory investment which I am required to make as a manager of these funds. So how do I subscribe? I subscribe to the units of the funds which I manage, which are listed here, my lord, in my books. Now, these are, my lord, the historical figures of investment. These are not the market values which I am showing today, of which there has been a valuation reports which I have provided. And all, not only the, your lordship has seen the order which is made, it's not only the securities which I've provided, but the learned judge goes on to direct that whatever investments which is, because the type of security is specified, my lord. He's a secured creditor, no doubt. But the type of security is specified, that is my investments, because these are the only assets which I have. And if my bank account is injuncted in any manner whatsoever, it would bring a going concern to its knees.
So there is no notice calling upon you to furnish additional security.
Subject to correction, my lord, these are all notices under 259 onwards, which my learned friend referred to, are notices under the SARFAESI Act. I was not there at that stage. If they could, 235 onwards is the 13.2 notice where the loan was recalled. Then kindly see the default notice at 217, please, my lord. Kindly see the defaults listed there at 217. Kindly turn to 218, please, my lord. The defaults are listed not in terms of Article 3.4, that the security which you have furnished is insufficient to cover the outstandings. This is the default letter which is of 6 July 2024, and before 6 July 2024, there's no correspondence. But anyway, these are the defaults which are listed. In his loan recall notice, your lordship has seen A, B, C, D, E does not talk of 3.4 or non-compliance with 3.4, and this is of 6 July, and immediately thereafter, the 13-2 notice is issued, my lord, on 24th July 2024, if I'm not mistaken. $235 is the loan recall notice. 13-2. And kindly see what they call upon to provide. They don't say create, furnish, or create. The 13th, the authorized officer cannot call upon me to provide further details. He is to take charge of whatever is there as is furnished to him in the loan documents. Now, whatever it is, my lord, whatever the transaction between the parties is itself, there is no dispute that I have not received 26 crores. But the purpose of receipt of 26 crores is in question. The learned single judge has noticed that, my lord, your lordship will kindly come to. And this is a defense which was squarely taken.
25.
Paragraph 26, if I may trouble your lordship with, my lord, at page 14. I'm sorry. Can you see paragraph 26, please, my lord? The loan was extended by a petitioner to a wholly owned subsidiary of its parent company, which in my prima facie view creates a unique situation. Now, your lordship is in the commercial court, my lord. I don't need to tell your lordship, my lord. Your lordship sees the rate of interest which is stipulated in the loan document, 12% per annum, would itself speak volumes about the nature of transaction between the parties in 2020. And kindly see my supplementary affidavit, my lord. The matter doesn't rest here. In the NCLT proceedings, my lord, the administrator of the petitioner takes out an application under section 66 of the IBC, and which are called the acronym is PUFE transactions for prevention of undervalued and fraudulent and extortionate transactions. And in that application, now may I just place a paragraph? It says that this is not a loan transaction. He is the petitioner's administrator in the NCLT likes this. The administrator appointed at the instance of the Reserve Bank of India. When the petitioner company, he says this is not a loan transaction. The rate of interest could not have been 12% per annum at that time because the petitioner was borrowing at 16% per annum.
Lord, my learned friend is going off the record. Please show it. Please show it. Please show it. No, show it.
Yes.
Show it.
Kindly have my supplementary affidavit and my vacating application. But I submit, my lord, this order adequately protects the petitioner. Full liberty has been given, my lord. They ought to have. I'm sorry.
Before
My 66 application. जज का लिए कॉपी चाहिए ना 60 निकाल ये तो ऊपर जीपी अग्रवाल हेलो प्लीज टांगी मंगाओ
एक बार एग्जाम्पल से प्लेस करिए मंगा रहे हैं
যদি হয় এটা আর যদি কালকে না পরশু দিনে কিন্তু নন কমার্শিয়ালের আগে আমরা এটা মিস্টার
Your Lordship,
Thakkar, we take up that other matter now. Tomorrow, after appellate side, if we are able to reach original side matters, this will be the first matter.
please, ma'am.
That is how it will be listed.
Please, ma'am.
Even if tomorrow it is not taken up, then day after tomorrow, this will be the first matter.
Please, ma'am. May I make an out of turn mention if with your Lordship's kind permission? Item 6, my lord, that matter which is there where my loan recall notice has been stayed, my lord. There's some urgency there. Mr. Shah was not there. Mr. Bose was leading me. He's here, my lord.
Well, last Monday,
But
I
if your
wanted,
Lordships could
then
kindly
my lord,
take it up.
my Monday, this Monday, my,
Is there some
last Friday,
council issue?
yes, 5 became 4. My lord, and I missed my turn.
Let us see. Let's see. We can't fix it. Not 4 days, 3 days before the vacation, Mr.
My difficulty with leave from my learned senior, my lord, my section 7 application before the NCLT, my lord, now that is getting affected and it's fixed for hearing on 16th of
We
October.
appreciate, Mr. Thakkar, such difficulties are being faced by several litigants.
I leave it to you, Lordship.
Lekho. Mr. Bachawat, learned. This appeal is directed against a judgment and order dated June 18, 2025, whereby an application under Section 9 of the Arbitration and Conciliation Act, 1996, filed by the appellant herein, being APCOM 1049/2024, was disposed of by a learned judge of this court. Stop. Paragraph. The appellant is aggrieved by the fact that the learned judge has reduced the extent of security that was operating in favor of the appellant. Paragraph. We have heard Mr. Bachawat, learned senior counsel representing the appellant. Stop. He has completed his opening submission. Paragraph. Mr. Thakkar, learned senior advocate appearing for the respondent, begins his argument but does not conclude. Paragraph lists the matter tomorrow. Tomorrow, na date diye din, kalke date diye din, with a note in the cause list that this will be the first original side matter. Ora kore nebe? Acha, tomorrow list diye dao.
Grateful, my lord.
My lord, only one humble submission. The next matter is mine, my lord. I am for the appellant. My lord, only one thing. On Friday, I will not be available. I am praying that the matter may be kept on 24th October, my lord, the opening day.
Modern.
Item number 5, yes.
Appellant.
I am the appellant. I'll give a notice to the respondent, my lord.
Do that. Kore dao. Jera bolchi dekhe na.
5. Next matter. 5. To be deeply obliged, my lord. Deeply obliged. I'm chill on the road. Thanks.
Confusion.
Chaudhary is appearing in this matter.
I substantially argued the matter before the learned single judge.
Oh, you did.
It's like the confusion. But I'm deemed to be present on most occasions in the appeal.
Sure.
And then not having argued for 2 days, he abandoned me and went away.
Yes.
But my learned friends have argued. But within 15 minutes, I'll just give you a lordship a broad outline of
সব কিছু রিলিজ করে দাও বাকিগুলো
what I intend to do. তাহলে বলে দাও ঠিক আছে
Yes.
So, Lord, what has happened here is my learned friend had permission from the railway authorities in respect of a pipeline to carry water. Now, the admitted position is not that pipeline permission came to an end in 2017 and it had long been in disuse. Your Lordship need not be troubled with papers.
No,
Not, I'll try not to refer to
No,
anything and just
just
give you.
it looks bad without papers, so we have kept some. May not be of this case also. We don't know. Yes.
Now, Lord, the admitted position is not that anyone who's occupying railway land, not their possession is only permissive. It is at the highest position of a licensee. Everyone is proceeding on that basis. It is merely permissive possession. Now, he did not pay for many years, so it would have come to an end. In any case, that permission expired in 2017. Now, after it expired in 2017, I had a factory on both sides of the railway line. I wanted to connect these with a railway underpass. So, Lord, I applied to the railway authorities for permission to make a tunnel underneath the railway track to connect my two factories. The railways obviously treats his permission as having come to an end and permits me to go through the pipeline, go underground and take it out under the railway land and take it to the other side. So permission is granted for two such railway underpasses. And admittedly, we construct, build, it's made operational.
When was this?
2017 is when his license expired. We got one permission in 2019 and the other in 21 or 22. The other in 22. Now, all this while he's asleep. Nothing. That pipeline is gone. Railway treats it as gone. My railway underpasses are built, becomes operational. Then one fine day, we find these JCB excavators come and start digging right at the edge of my underbridges. So we complained to the railway authorities, saying this is what is happening. Now it seems that in the meantime, what happened was railways revived this permission. Now, calling it revival would be strange because one document shows that a fresh permission is granted with effect from sometime in 2024. The other document says it takes effect from a back date. But these documents didn't surface. So we complain that this is going on. Now, without any hearing given to us, without considering any of the safety consequences, and take it from me, there is no study to show that this is not going to affect the safety of my railway underpass. They go ahead and permit them to build. Now, we have given notice, no notice given to us, no hearing, nothing. They come and they dig right at the edge of my underpass with a gap of a few centimeters. I'll show that. Now, what effect this would have on a railway underpass, which is going under railway line, no consideration of it. They proceed with undue rush. After the writ petition is filed, they go ahead and complete it also. And I'll show your Lordship, what they do is completely contrary to what could have been permitted. And there are findings to that effect before the trial court. So, this is what we came in challenge with. Now, once we came in challenge, the appellate court directed the railways to disclose various things. Firstly, to show whether backdated permission could have been given with effect from a backdate. Number two, could it have been given without considering that third-party rights have now come into being? Specific order of the division bench. And thirdly, to show if any safety aspects have been considered. Now, the documents disclosed don't answer any of these points. They filed a detailed report, and I'll take your Lordship into that. So, it was in this background that now the trial court held 5 things. If your Lordship just gives me one moment. Trial court, I'll take your Lordship into the order. There isn't sufficient time. Number 1, wayleave permission was granted to the appellant. It had expired in July 2017. there was no existing value permission to them at the point of time when they were admitted into CIRP. So it was gone before it went into CIRP. So going into CIRP by itself cannot not magically revive something which has lapsed. That's a clear finding. So it could not have not come back to life as was argued by them before the trial court. It was as if not going into CIRP, some kind of magic wand, all leases, licenses, everything not suddenly become alive. So, Milord, this is another finding over there. Then, Milord, the learned judge said the renewal had to happen before the expiry of the previous permission. The railways policy itself did not permit it, and it was contrary to the engineering code. So, Milord, the findings against them on each of these, and then comes the Milord portion which perhaps my learned friends should have explained, but they have not. Whether, Milord, in the guise of carrying out repairing work, this whole thing could have been done at all. Because their letters only say that it's as if the pipeline has got a little affected in a certain areas, it requires minor repair works, and in the guise of it, they make something which is not permitted, i.e. a pipeline going overground. Now, the railway policy does not permit that at all. The permission granted does not permit them to go overground either, the permission itself. So, in the guise of repairs, all of this is done. And that is what actually had a bearing on it. Also, given the fact that despite a complaint, we have never heard, we have never asked to provide drawings, and the drawings that they provide has no bearing on the safety features at all. This is the long and short of the matter. I'll make my submission on the next day, if your lordship.
When should we keep it?
Please keep it sometime the first week of.
Give us a mutually acceptable date after the vacation. First week after vacation.
Could it be after the 3rd of November? But he's going on a mountaineering course. So
just give us a date. Give us a date.
Yes.
Even now.
Tuesdays, I thought Tuesdays. 4th of November. That's a Tuesday.
So it's here only.
This is an appellate side matter.
No, my lord, it's a non-commercial matter.
Appellate side.
Yes.
Appellate side.
Thursday. Give us a Thursday.
So 6.
6. Mr. Bachawat, learned senior counsel representing the respondent, begins his argument but does not conclude. Paragraph. List this matter once again on November 6, 2025. Stop.
My lord, this kindly, my lord, treated as part heard.
On the paragraph, on the request made by on the request of learned counsel for both the parties, and since we have heard this matter in extenso, let this matter be treated as hard in part by this bench. Hard in part.
One.
Oh, great.
I am appearing to the respondent numbers 2 to 6. Appearing for respondent numbers 2 to 6 in this matter. Railways matter.